were those. The Constitutional Court did, well, gave it to some, maybe not to others. It said, no, the MPs, you cannot extend your term, but for age limit, it gave it a green light. And the petitioners went to the Supreme Court, and today, the Supreme Court is going to be delivering its verdict. They told us that at 10 a.m., they will be getting started. But as a way to cross over to that, let's have a discussion with some good people, lawyers and political analysts, because perhaps there's a lot more politics in this particular case than there is the law. Let me get to my guests. Peter Walubiri. Peter Walubiri is a senior lawyer. Good morning, Chief.
Good morning, viewers.
We're also joined by Fiona Wall Nabasa. Fiona is the Vice President of Uganda Law Society. Good morning, Madam VP.
Good morning, Joel. Good morning, viewers.
And last but certainly not least is a lawyer to be. Bernard Sabiti is a political analyst, but he promises that at some point after he's done with his PhD, he will be joining law school. Good morning, Bernard.
Good morning, Joel. A pleasure to be here as always.
All right, Fiona, let me start with you. Uganda Law Society is one of the petitioners.
Yes.
Perhaps if you could just walk us through a bit of history, how this all began. So you guys decided to go to court.
Yes.
What were you petitioning court about? Just a bit of a recap for our viewers.
Well, as the Uganda Law Society, one of our tenets is to uphold the rule of law. And one of the pillars of rule of law is in our government is democracy and also being able to self-determination by the people of Uganda. So when this bill was passed and Court of Appeal upheld, when we went to court, first of all, we went to court because we thought that the process through which this bill was passed was erroneous and questionable. And we also felt that what Parliament did in extending their own term was denying the people of Uganda the right to self-determination, the right to decide who was to represent them for those 2 extra years. So we went to Court of Appeal, to the Constitutional Court, and we had this decided partly in our favor. And unfortunately, we felt that because you see the Court of Appeal said that despite the fact that it had taken note of the irregularities of the way the bill was conceived, passed, the periods between the 3 hearings and all the elements surrounding the passing of this bill, they still upheld it. So we felt that they were erroneous in doing that. That is why, that was really the basis on which we appealed. That they were cognizant of the fact that there were questions around how this bill was conceived, heard and passed by Parliament, and yet they still upheld it. So that is where, as the Law Society, we felt that the Supreme Court should determine this matter. Yes.
Interesting. Peter, let me ask you a wide-ranging question. I don't know whether this might be sub judice, but what are your expectations from today's ruling?
I don't expect much change from what the Constitutional Court decided. I would be pleasantly surprised if the Supreme Court took the bull by the horns and reversed the decision which allowed the age limit for the president to be removed from our constitution. Honestly, I think, save a few comments here and there, the judgment of the Constitutional Court will be maintained by the Supreme Court. But I hope I'm wrong, and there are surprises, but I don't think so.
All right. But let's talk a bit about the politics of this decision. Assuming it goes as Council Olubiri is saying, that's the talk, from literally everybody.
Yeah.
Do not, for starters, do you actually think, politically, the justices of the Supreme Court can make this any different, especially for the age limit? Because that's the crux of the matter, if you like. Like I was saying, there's a plethora of other issues that were determined, but that's the hugest.
That's the elephant in the room. I do not, as the council said, of course, I don't expect the justices to overturn the decision of the Constitutional Court. I think that would be, like, as he said, such a huge precedent that we have not seen in this country in a long time.
Although the right one.
Yeah, it would be the right one, of course, and that would really be the re-emphasizing of the independence of our judiciary. Unfortunately, I do not think that the president being the one that appoints members of the Supreme Court. I know of late across Africa, many rulers, many leaders have realized that actually the Supreme Court or the justice system in its entirety is a very, very important tool of legitimization of their, of their power, because we know most of them obviously don't win clean elections. They always know there's always this expectation is that the opposition will always go to courts. So they've made sure that the courts are staffed with people for whom they can expect no margin of error. I would not even expect actually the one dissent we got under the constitutional court decision, probably we won't have one today, because when you look at the constitution of this court, it's clear that almost it's a foregone conclusion on how they are going to decide. I think the big lesson for the opposition and other forces of change in this country is that it's a big mistake to always consider the courts or the justice system as a fallback position.
What are the options? Because if we are saying, we must uphold the rule of law.
Yeah, what I'm saying is, yes, but this is the reality. You have to win elections. You have the fight really should be fought at the ballot box to make sure that if a decision doesn't really go in your favor,
how do you win flawed elections?
That is another, we are discussing the challenges, of course, they exist, but I think you can look across Africa, with the exception of Kenya the other time. The DRC, for example, we knew that the president, his main man, has lost an election so badly that he realized that if we were to rig for him, for his chosen candidate, it would probably tear the country apart. But he had the Supreme Court, and so he played his gymnastics, and he still got his man, even though the first option didn't work. But we know that leaders are increasingly realizing that actually the Supreme Court is a very important, especially leaders of hybrid regimes. These are regimes which are neither entirely autocratic, neither openly, democratic. So they organize elections, which really are selections. They rig the ground game to the point that it's almost impossible to defeat them. And then they know that they will be, getting legitimacy, especially in the eyes of the donors who are obsessed with these procedural matters of elections. Otherwise, if these leaders had a better option, they wouldn't even bother organizing them. But elections have become very important because they legitimize their pseudo legitimacy, because we know most of them don't win elections fair and square. So they are very careful to make sure that a person being appointed to the Supreme Court is a person that has been entirely vetted on all dimensions, that there can be no surprises. So I do not really think there is going to be any surprises. I actually think that we won't even have one single dissent this time around.
Fiona, so Bernard raises an interesting, element to this, that the courts of law become a way to legitimize certain things. Almost every lawyer you speak to, or any ordinary folks around, they will tell you, look, we know how this is going to end. And so there are those who are thinking, but now for Ugandan Society and a couple of others that will go to court, it is in a way to sanitize the process, because court is going to stamp, and so that will mean all is good.
I disagree.
And yet, so the Muntua Wansi out there will see this whole process as, wait a minute, you guys seem to be trying to legitimize this. So because that's what
I really disagree with that position, because if that was the case, then we would not be wasting resources going to court. We, as the Law Society, have boycotted such things before when we did not believe in them. And I would also like to disagree with my member here, because one of the things that we need to realize is that we've come a long way as a country. Yes, other jurisdictions are doing certain things, and yes, we've done certain things in this country that have caused us maybe to doubt about the independence. But for me, just the Court of Appeal, the Constitutional Court decision, the dissenting judgment there, and the courage with which it was delivered, for me,
But then what? Because at the end of the day, the majority take the day.
there's always a dissenting judgment, and there's always the majority. That's the way things are. And what I want people to understand is, if we are actually advocating for the rule of law, then we should strengthen our systems. For instance, this bill was passed by parliamentarians who represent the people, and people had problems with the people that passed this bill. But come 2021, you might find the same people be voted in. So I think we need to interrogate our very systems and how we're using them as people. And then the second thing I wanted to say is that the example of Kenya, for me, shows that there's a shift. There's a fundamental shift. So I would like to be optimistic. I would like to, because they're the Supreme Court, and I do not want to question that. I don't think I have a right to question the qualifications of any of the members of the Supreme Court. I think they've earned their place in that court, and I think we should give them the due respect and allow them this moment to show us who they are and where they stand. I think we should not hold them guilty before they are tried. It's not fair.
Well, perhaps one would say it is...
it's okay to be sarcastic.
To jack the process.
It's interesting to be sarcastic, but I think if this was, for instance, the position of the Law Society, we would not have wasted resources going for the appeal.
Okay, so Fiona has very high hope that the Supreme Court might do something different. I don't know
whether they disappoint us, we shall also, we shall also react appropriately.
Mr. Olubiri, you see, the question of, for example, substantiality comes up when whenever there's a petition, election petition, court will say, look, there was rigging, yes, but not substantial enough. She just told us the reasoning of the Constitutional Court was, look, there were errors, and and we take judicial notice of them. But then again, we have decided this way.
Yes.
And then so the ordinary folks out there are thinking, but wait a minute. So you admit there were problems, but then you are not dealing with the problems. You're saying, nonetheless, we have allowed, the problems notwithstanding. How does the balance get struck?
You see, these issues are not new. We canvassed in 2001 in the Kizza Besigye election petition the question of substantiality of what amounts to a free and fair election. We were arguing for a higher standard of democracy. We were asking for an interpretation of the Constitution and our laws which would breathe life into our Constitution and meet the aspirations of the people of Uganda. The Supreme Court in 2001 adopted a lower standard for democratic dispensation. When Fiona says we've moved, we have actually not moved. We are stuck where the Supreme Court fixed the standard in 2001. That has been the standard. That standard was adopted in Kenya. Kenya tried to move away from it in this recent judgment. So this is the...
And we can.
This is perhaps the only last opportunity before we have a life presidency for the Supreme Court to reverse the standard it set way back in 2001. Actually, truth be told, this appeal now is a trial of the Supreme Court. Does it have the wherewithal to really breathe life in our Constitution? You see, the courts set the standard. Is the Supreme Court ready to set a higher standard? If we are discussing here, but behind here there are soldiers whom the public may not see, but we are under intense pressure. Are we a free people? You see, if you are filtering water, you can use various levels of filters. One can have big holes and therefore some impurities pass through. One can have smaller holes but some impurities still pass through. One can have a very fine net. That is the role of the Constitutional Court, and if it errs, then the Supreme Court is supposed to correct that, to set the proper standard. If people are being beaten in Parliament as they are debating, is that a legitimate process? How much violence can we condone in our political dispensation for us to continue to talk about the will of the people? That's the real question, really. And I don't think that it's a question of striking a balance, because there cannot be a balance between evil and good. We are either a democratic country or a dictatorship. There can't be something in between. It's not known in political theory. You can pretend to be a democracy, which we do pretend, but they are universal standards. So the judgment today, really, and one of the reasons for me I continue to encourage people to go to court, is to put our judiciary on trial until the time comes when it is very clear to all and sundry, as our colleague has said, that perhaps we should not be looking to the judiciary. Perhaps we should look elsewhere, and that day is unfortunate. I wrote in one of the papers long ago that will be a sad day where the people, because you see the judiciary, especially the Constitutional Court and on appeal the Supreme Court, are the guardians of our Constitution. We continue to beseech them, we continue to trust. I like the optimism of Fiona. I shared that for some decades. I'm not that optimistic any longer.
You lost hope a long time ago.
I've not lost hope. Oh, I think the next week I'll be filing some other petition or something on
That's
other
optimism.
matters.
Well, it could be work.
But for me is to constantly put these fair men and women on trial.
Okay, let me bring Bernard in on this whole question of, okay, so we have entrusted our parliamentarians to pass law, to legislate on our behalf, and then they do otherwise, and then we entrust the courts of law to put things right. And then they let us down. We remember what happened with the term limit removal. Members of parliament were given money.
Yes.
We are bribed. That is for sure. Okay, and then we had stories about what happened with the whole court system, and then the people were left there. You know, similar story here. Members of parliament were given money, as you all know, and then we go to court.
But
so
who are these members of parliament? How do they get to parliament? You see,
yeah, be that as it may. So they are there, and then, so the people are thinking, so where am I left? So what is the recourse for me? The Constitution is saying you have the power to elect leaders, power to do all these different things, but then I'm left in abeyance because all these channels have let me down as a person.
Well, I think the council asked a very good question. How are these members of parliament elected? I think there is this fallacy within the population that we actually have a representative democracy where actually we elect our representatives on a fair shake, on a leveled ground, but that's not the case. I don't think there is any normal parliament, especially in countries where democracy has been around for a while, where you have more than 3/4 of the parliament representing the ruling party. We basically you end up having a rubber stamp. In most of these other democracies, power is more evenly distributed. Governments even struggle to form a government because power is so almost evenly distributed that you have to be willing to compromise to work with the others in order to actually form a government. what we have in most of these hybrid regimes, Council said that you can only have a democracy or a dictatorship, either or, but actually political theory is increasingly recognizing that these guys have realized you can have your cake and eat it at the same time. So these hybrid regimes are regimes where it's neither a democracy nor an open dictatorship. In this century, these dictators are smart. You are not going to have an Amin, somebody who shoots people openly, ties them to, you will have a parliament, but which is powerless. You have a judiciary which you control. So long as you have this semblance of a democratic dispensation, which obviously donors want to sell to their constituencies back home, the elections are held, but which are totally fraud. So I really think that you have to overhaul the whole system if you have to have, any semblance of order when it comes to parliament, because these MPs, first of all, many of them, Joel, my history, I know the process quite well. I'm a former contestant. Some of these MPs sell their property. They procure debt. They do all sorts of crazy things in order to win these positions. You know as well as I do that any sane businessman will tell you that once they are making an investment, they expect a return on investment. So if an MP has spent almost all his livelihood to come to this house,
so
and
then there goes the milk and politics.
Exactly. And the president knows this very, very well. The president does not want an empowered parliament, because that will come back to haunt him, because then these MPs are going to be making independent decisions. Once that is the case, his position will become, you will be in jeopardy. And honestly, for me, the question right here is not even about the legalese. It's probably going to be found to have been done in a legal way. I think something being illegal, though, does not mean that it is immoral. There are a lot of things in history that were legal, but exactly. So I think what the MPs, the worst position they are in now, the opposition and the other forces of change, other activists for legal, legal order in the country, what they can do right now is to expose the moral bankruptcy of some of these decisions. This is why I still believe that actually this process is still important, even though I think it will in the end not change it won't really overturn, for example, the decision, but I still think the process is important. The arguments are important. When you are listening, when we are still educating the pros and cons of the different positions before the Constitutional Court passed their judgment, you could clearly see that some of the issues that came out were rather absurd, and people were not aware of them. So these arguments, to the effect that they want to expose the moral bankruptcy and the absurdity of this kind of dictatorship, these processes are very important because they bring the key issues to the public. But in terms of changing the status quo, unfortunately, we are not yet there. This is why I'm saying that once the president can still appoint members of the Supreme Court and the other high courts, then I would say, like in America, what they do is they fight for the presidency to the death, because they know once a person has that executive power, they are going to do things that the other guys will not really have power over. So if you want to change the status quo, unfortunately, I think you have to fight way before things reach to this level.
All right, Fiona. So Uganda Law Society, for which you're vice president, petitions, but then at the end of the day, probably things don't go your way, and we must release your IC court getting settled. So in a very short while, action should be starting there. But then what at the end of the day? You go to the Constitutional Court, it rules in a way you're not pleased with, you appeal to the Supreme Court, and maybe they don't give it to you as well. And then what? So you keep writing articles and make noise, and then what at the end of the day?
Well, again, I just want to qualify the situation we have, especially with what Mr. Walviri said about what happened with the BCJ petition. One of the things that's different then is that was an election petition that we were dealing with. This was a parliamentary constitutional amendment.
Yeah, but it's still a matter of
why I'm qualifying it is that I feel that there is what do you call it? There's less.
That's your lecture, your former lecture.
When the when the Supreme Court upheld what they upheld then, the reasons they gave was how expensive it would be to conduct another election, what would be at stake. Right now, I think there's so much more at stake, but it would cost this country less to have the Supreme Court do the right thing. So that's the basis of my optimism. Secondly, you're saying now what? Of course, if we do not get what we have appealed for, we are going to go to the ballot in 2021, and that's why he's calling them hybrid dictatorships. I call them hybrid democracies, because a dictatorship, I think I like to call things as they are. A dictatorship is where one person decides where everything goes. I do not think that that's
we not see that in this country. No, parliament are taken to Chankwanzi, given money and beaten.
I have said something before. I have said that our society has to learn to take responsibility for the leaders that we've put in power. And he talked about
these people in power.
Let me finish. We've talked about poverty. You know, our leaders are always defending the people's bad decisions. That is because they're poor, or they're this, or they're that. Parliamentarians are looking at this as a business. But if each of us do not take responsibility for our positions and do the right thing, because you see, a parliamentarian is looking at it as a business. The local person is looking at who's going to give me something. While we are busy doing all that, the processes are going on, and it's hard to defend them after. So if we go to the ballot in 2021 and the court has allowed the president to be on that ballot, then it will be another opportunity. This time it will not be the Supreme Court on trial, it will be the people of Uganda on trial.
How do the people get to be on trial in an election which the Supreme Court itself has said is not free and fair? Bribery does happen, intimidation, there's deployment. This whole country becomes like one barracks altogether.
Because at every opportunity we have a chance. We have a chance to stand. Yes, there's intimidation, but there will always be people willing to pay that price. Yes, there might be bribery. There will always be people willing not to take the bribes. That's what I'm saying.
And by people willing to pay the price for intimidation, you mean death, because a number of them have been killed, shot dead during these electoral processes and so on. And maiming.
I think, honestly, that our country has gone through so many things, and for me personally, as a lawyer, one of the things that grieves me is our level of lack of respect for the rule of law. From the grassroots, right from the grassroots, I feel that we are empowering. We are creating this hybrid. We are keeping this thing alive. We're feeding it. We're feeding it with our corruption. We're feeding it with our reduced levels of willingness to sacrifice for the good. So what if, if you get imprisoned?
Would you be willing to do that yourself?
Yes, for the right thing, yes. I think we should. I think if these questions come up, I think we should be willing to stand up. But what I want to tell you, Joel, is I will not stand for someone telling me that because they invested a lot, it's okay for them to take a bribe and sell our country. All the things that have changed the constitution to the level it is right now, to the tatters it is right now, have been our people, our own parliamentarians. I think we need to take responsibility at the different arms of government, at the different grassroots levels, and see what's happening. Just the LC1 elections, we saw what was happening there. It's a reflection of what will happen. So if this court decides against us, and in 2021 we have to decide, we need to remember that each of us will be on trial for us to prove that day that we're willing to stand and do the right thing.
Well, again, the people will say hopefully we can be allowed to be put on trial, as opposed to waiting for a verdict elsewhere. Anyhow, we need to release Fiona because she needs to run to court as one of the petitioners. But as we do that, let me cross over to my colleague Herbert Ziwa that is standing by. Herbert Ziwa, I'm sure you are at the premises of the Supreme Court. We understand that the Justice of the Supreme Court... Herbert, can you hear me, by the way? Herbert Ziwa?
Wherever you're watching from, we're indeed here at the Supreme Court, and we're just a few minutes to the Supreme Court ruling in the constitutional petition challenging the removal of the presidential age limit by Parliament. The mood here is set, and both sides have already come here in court. The side of government led by the Attorney General Mwesigwa Rukutana, and also William Biaruhanga already here. We also have the petitioners, including the lead counsel of the Uganda Law Society, Wandera Ogalo, the lead counsel of members of Parliament. This is Honorable Elias Lukwago is also here, and the 6 members of Parliament who petitioned the Supreme Court challenging what came out of the Constitutional Court ruling in Mbale. Some of the petitioners are here with me, and I want to speak to the government, to the opposition chief whip, Honorable Ibrahim Semujung. And Honorable, what is your expectation as we head into this Supreme Court ruling this morning?
I think the part of the reason we appealed was because the evidence we presented in Mbale was not properly evaluated. But also, this matter, we are just representatives of the public. Everybody is interested in a country that is governed properly. So my expectation, this being the last court in the country, is that their judgment today will take care of all the issues that were not addressed in Mbale. First of all, law is not mathematics, that 1 + 2 is 3. You must deliver judgment that fits within the circumstances. Because if you read the preamble of this constitution, it starts with history. Knowing the turbulence, knowing what we've gone through today, we are assembled, we are making a constitution. So this constitution was made to address the history of Uganda. History of bloodshed, history of coups, history of people grabbing power by use of guns. And every single opportunity that was put in this constitution for this to happen has been removed by the current administration. So we expect this court to restore what Parliament in a mob justice style removed. If they don't, this will be the darkest moment in our history, because the country will be remaining with the same options that have presented themselves to other countries like Sudan, like Algeria, like Libya, and we don't want to take that road. So I only hope that the judges will be strong enough to look into the eyes of the emperor and tell him, please, let's keep the constitution. That's why we came here.
Honorable Jonathan Oduro, this is the court of last resort, the Supreme Court, the last court in the land. What is your expectation as we head into the ruling?
Well, first of all, we are ready to receive the judgment, and I know that this bench of the Supreme Court is experienced, they are well read, they are well schooled, so I expect them to agree with us that the case we brought before the court is important and will shape the future of this country. They have a chance to save the country from going into the drains, and we're also testing whether our judiciary has now matured enough to be responsible, to take decisions that would be in the interest of Ugandans. I want to add that the political crisis in this country started around 1967. One of the cases of expert Matovu was endorsed by court. So since then, many other leaders that came have been acting with impunity. Now this Supreme Court can put an end to impunity to some of the political maneuvers that have been going on in this country.
Thank you very much, Honorable Jonathan Oduro. Honorable Sewanyana, there are already predictions out there in the public that this is a done case. You have no hope. The president will still stand in 2021, and the Supreme Court here is going to just confirm what happened in Mbale. Are you holding the same view?
Of course, what we want to confirm today is that whether we still have rule of law in Uganda and constitutionalism, because our hopes were in the first court, the Constitutional Court. Then when we lost at the Constitutional Court, we had to appeal to the Supreme Court, thinking that we might get some remedies, we might get some fairness from this court. So that is what we hope. And I hope this, and I think this is our last step towards constitutionally fighting for rule of law in Uganda, which we wouldn't like, because as Ugandans, we would like governments to change in a proper way. in a constitutional way. Now that we had a chance where the president is going beyond 75 years, we should respect the constitution. So that is why we are here. We hope that the judges do consider so many things, the future of this country and the history of our country, in deciding this case. We had so many issues. For some of us, we are sent away from participating in the deliberations on that day. We were denied the chance to represent our people. So that is one of the issues that we are raised to the Supreme Court. Another thing is the affection of the basic doctrine of the Constitution. Because the Constitution has some elements where when touched, they do affect so many sections of the Constitution, and this is one of them. So we think that if we are to restore constitutionalism in Uganda, we have to respect such, and the judges should consider that. Why we came here is that we had hopes in the Supreme Court. So let them not make us lose hope, and the whole country from the Supreme Court. We think that justice still exists, at least at some extent, in Uganda. But it is today that they confirm that there is no justice in Uganda when they do decide in favor of President Yoweri Kaguta Museveni's NRM, MPs, and all that happened, and what all happened in 2017 amendment of the Constitution. We hope that the Ugandans do support us in whatever decision we get today, because each decision has consequences. When we lose this petition, hopes will be gone for all Ugandans. That means we should have another angle in which we can fight for our constitution. And when we win, that means that we have won, and we have to go back and do consider what to do next towards fighting for the constitutional.
Thank you very much, Honorable Sewanyana. This court is expected to rule against 8 issues that were raised by the petitioners, but the most important is how the Constitution was amended, Article 102B of the Constitution, that removed the presidential age limit, the upper and the lower presidential age limit. One of the petitioners in this case is Council Mabirizi, and I want to speak to him. Council, you even went to court demanding that the Supreme Court should immediately give you the ruling. It is the D-Day. What is your expectation?
Of course, I'm waiting. As someone who invested in much time, resources, the authorities, I think I'm going to win. Unless otherwise, you know, when you do your part and prepare your garden properly, you expect to harvest something. Unless maybe a hailstorm falls on the village and then your crops are destroyed. But otherwise, you expect to get some fruits.
I was with you in Mbale, and you had the same expectations and hopes. But things, okay, you won in some cases, and you failed to get some of the things you put before court. This is the court of the last resort. What could be your next step?
You see, that's why we came here. That's why the framers of the Constitution thought that when you are dissatisfied with one court, then you go to another one. Because possibly one court may make a mistake, which this one can correct. But secondly, this is the final court in Uganda. The other day I was telling you that if there involves matters of rule of law, then I may go to the South African Court of Justice to determine whether this country is still on the rule of law or the African Court of Justice. But for here, we stop here. But I expect I will win, and let's wait what they determine.
Thank you very much, Council Mabirizi. We are still here waiting for the 7 justices that sit on this bench, and any time from now they are expected to make their way from the other side, come and occupy their seats, and we have been told that each of the 7 justices will have to read his or her judgment. So that means we are still here for about maybe 3 to 4 hours as these 7 justices of the Supreme Court deliver their final judgment in this constitutional petition that is challenging the removal of the presidential age limit and other issues therein. Thank you very much.
Okay, thank you, Herbert. You are coming to us live from the Supreme Court, where the verdict is going to be delivered. And as he says, the expectation is probably that each of the 7 justices will deliver their own verdict. But let's wait and see how that goes. Let me just come back to my panel here and we see how we wrap it up. Hopefully, the justices will be walking in a very short while. Councillor Peter Alubiri, the question of the President appointing judges and justices of the Constitutional Court and the Supreme Court, every time it keeps coming up, and people will say, look, we don't expect that there will be anything you know, on the side of the people, as it were, because these people were appointed by the president. They do qualify, they have earned their places. When you look at their CVs, many of the CVs are rosy CVs, amazing. Would this be, because you're one of the pessimistic ones, you're saying you would be pleasantly surprised if they rule otherwise. Would it be any different if these good people were not appointed by the president, if there was another modus operandi? I don't know which one, maybe Kenya's example or whatever the case might be.
I don't think the mere fact that the president appoints the justices and judges is the most critical. There is supposed to be a Judicial Service Commission which recommends the appointment. The problem is that the president still appoints the members of the Judicial Service Commission, and he largely appoints, with great respect to the members, those that are compliant. Parliament is supposed to vet the appointments, but we all know that the election or the selection of Parliament is equally flawed. So it is a systems failure. We never elect a president. One is imposed on us. He then appoints people, many of whom looking for jobs, to the Judicial Service Commission. But the other fact you may not know is that, in fact, the Judicial Service Commission doesn't recommend the president and other interested parties send names to the Judicial Service Commission. So in effect, it is the president recommending to the Judicial Service Commission and the Judicial Service Commission pretending to recommend. Then we have really a bread and basket, with great respect, Parliament,
very true,
purporting to vet. Perhaps we should experiment with a more robust involvement of the public in the appointment process, where nominees for appointment are openly vetted. Members of the public should be able to have audience with the parliamentary committee on appointments and raise issues about these proposed names. As it is now, even if you wanted to raise issues before Parliament, the best you can do is write a letter which may never be acknowledged. But if there was a public debate, the way they do it in America, perhaps we would weed out some timorous souls from these appointments. But there is the whole question of the degeneration of the body politic in Uganda. You see, for starters, many viable people, many intelligent people, many good people have been pushed out of the political processes because it is dirty, it is rough, it is expensive. That's why you get those who are unemployed or unemployable ending up in Parliament and in the councils, largely. You know, people who are either unemployed or unemployable. They are the ones taking up political space. They are the ones vetting these.
It's probably because the very able and qualified, more qualified than these, like Councillor Peter Alubiri, will not throw their hat in the ring. They will not want to participate.
At least Councillor Peter Alubiri participates. But you see, who is willing? How many people are willing to sell their houses to go and buy votes? How many people are willing to recruit gangs of hoodlums to beat opponents? Because that's what you have to go through to win an election, whether you are for the opposition or on the government side. How many people are willing to go through this mud with a public that is skeptical, with a public that is demanding money? Because also they have been made so poor, they have been made so desperate. We need a complete turnaround. And it will take all forms. the recourse to the courts, judicial activism is part of it, political activism, the media, so that you stop practicing self-censorship also, because we give a lot of information to the media which never gets published for fear of the media houses being closed and so on, being starved of advertising revenue. All these issues need to be attended to.
All right. Bernard, before Fiona did leave to go and join her colleagues in court, she juxtaposed two situations, the election petition and this age limit petition. And the justices in the election petition said, look, you know, we probably would have asked for a repeat, but they looked at the cost of the whole process, monetarily and otherwise, politically and so on. And she was saying maybe the cost here is not as much, and so it should be easier for the justices to give it. Well, what would the cost be in this particular case?
The cost would be so high for the political establishment that they would not risk allowing that to happen. You and I know that the Constitutional Court, the way it is considered, especially by our rulers here, is just a part of, it's a cog in the wheel of the wider schemes and machinations to basically retain power. Anybody who stands against that goal will be crushed. There is no doubt about that. You remember when the president was talking about this age limit decision by Parliament, I think he was addressing the nation. He mentioned something quite curious to me. He said that he was thanking the 300 plus MPs who in his mind or in his judgment were the real national heroes, because they stopped him from taking what he called, I think, a third action, or going back to the bush. There's a way he framed it, which told me that if he had not gotten his way, he was actually thinking of problem rougher stuff in order to get his way. It shows you how extreme the ruling class is when it comes to keeping its power. So for me, it's really not about the cost or in terms of money. It's about what exactly does the ruling class wants, and are the courts willing to be part of the process to achieve that end? You know, many people have gotten excited by what has happened in Sudan. I've been seeing a lot of discussion, but I think people miss very important nuances, and counsel will be, I think, very eloquently explained the kind of conundrum that any forces of change in this country are in. Number one, you have to compare these Arab countries, these North African countries, which have accounted for probably 80% of the change that has happened in the last 2 years. Why is that the case? These societies are a little more advanced than us, not just socio-politically, but also economically. The GDP per capita in Sudan, I think right now, is over 6,000. It was about 8,000 in Tunisia. It was about 7,000 in Egypt. It does seem to me, counsel, that there is some element of freedom that's wrought about by some economic empowerment. Absolutely. There is a way the poor person who is thinking just about his next meal, it really would be very hard to, as Council Fiona was saying, to convince this person to be so nationalistic to go out there and get shot.
Actually, there are some who think otherwise. Bernard, who will say this one who is poor, who has nothing to lose, you know, is more of a time bomb, because for them they're saying, well, regardless, I am going to die of hunger, so let me go out there.
Let me explain poverty to you. You know, people have a misconception that poverty is just a mere lack of money. But poverty is also, there is a social poverty. There is a poverty of ideas. There is a poverty of political education. There is a poverty of lack of political connections or social political will. Poverty strips an individual of a lot of things, not just the material deprivation. poverty is about having, lacking confidence to articulate yourself. You know, the Maslow's hierarchy of needs. Just because somebody has some bare minimum to live on does not necessarily mean that this person is in the best position to do things. That's why we aspire for self-actualization, which tells me that these societies that have reached a certain level of economic empowerment have a way of thinking that is a bit different from people that are still deeply rooted in peasantry societies like our own. When you look at the kind of fervor and the insisting by these protesters in these streets in Tahrir Square or in Sudan, there's something different about them that we do not yet have here. And this is why our leaders will very presently look on as people continue to wallow in poverty, because they know a person who is very poor is a person that is very unempowered to question the status quo, to confront the status quo, because they are thinking about their immediate basic needs. Because before you think about self-actualization, political rights, you need the right to food, you need the right to water, you need the right about, for all these basic needs. So I personally think that the economic deprivation of our people has stripped them also of the desire to aspire higher. But you see, if you've never seen, you cannot begin to aspire to go in an aeroplane if you've never rode a bike. You get what I'm trying to get to. So I think the economics is a big element of it, and indeed, as some people were arguing, probably Bashir has been brought down in part by his success in lifting Sudan to a certain level economically. But I wanted to mention something about the legality. We are discussing legalities here, which to me is really not the most important thing right now. Well, I don't really think that our leaders care. It doesn't matter how they achieve what they want to achieve, as long as they achieve it. I think here we are flogging a dead horse. Why am I saying this? Because the level at which some of these issues might have been adjudicated, the very basic level of how we consult our representatives, our parliament, our local courts, as the council was saying, because the system is so flawed from the very beginning, it is very difficult to use that very system to right the wrongs, which, by the way, these systems, many of them were not put there to succeed. I don't think that there is any dictatorship that wants a strong court system, because then it will challenge them. So what is happening right now is exactly what our rulers intended to happen, that you will go through the procedural stuff, the mechanics of things, and we will come back to the same position, which is all they wanted in the first place. So I don't see any change that is going to happen today. I really would be very surprised, as the council said, if the judgment today is anything different from what many of us expect, which is that they will uphold the removal of age limit and life will go on, unfortunately.
Council, how do we, I'm looking at the population of Uganda, of course in comparison to the others that Bernard has been talking about, Tunisia, Egypt and the like. So there's the two schools of thought that if I have an empowered population economically and otherwise, they can stand up to their leaders. If you have a disempowered population, it's difficult for them to stand up to their leaders, but then they are a bigger threat. For example, you cannot easily drive along Kampala Road with your windows down and you're holding your phone. It will go. Why? Because this disempowered population is a huge threat. And so one would ask and wonder, how do we get that disempowered economically, socially and otherwise population to begin to demand for some of these things to happen? Because they are the way they are largely because they've been disempowered by the powers that be, the people in leadership that are making decisions on their behalf, for that matter against them.
Look, I wrote an article on liberating African civil society. And my thesis is this, and I agree with Bernard. Poor, disempowered people can never free themselves. You see, if somebody tasted bread yesterday and you deny him bread today, he will riot so that he goes back to the status of eating bread. But if somebody has been eating raw cassava for the last 10 years, he's never seen the niceties of boiled cassava, he's never seen bread, he's never seen all these other things. He will not aspire and fight for those good things. So the only way you can liberate these disempowered people is to organize the sections of society that are already empowered.
Which would those be in our case?
You get your journalists who already have the information. You get the intelligentsia. You get the working people. You get the traders. You get the business people to organize and challenge the status quo, and in the process begin to lift up those who are desperate, who are disenchanted, who see no future.
Council, I'm thinking about these groups that you have mentioned, and
that is why
are they not the biggest problem? Because the intelligentsia are the ones who will, for example, give a stamp to some of the most ridiculous post-trust policies that have been passed by government. The intelligentsia are the ones that are being given a little pennies here and there.
Let me tell you an example. In 1997, I was counsel in a petition to challenge parts of the 1995 Constitution. And the lawyers in this city said it is madness. How can you file a petition to challenge the Constitution, to challenge government? Today, because of the leadership we took about 2 decades ago, the whole law society can now file a petition. You see, the intelligentsia, those, they can begin to see that there is something to economically lose or gain depending on the quality of the politics. I'm talking about the lawyers. The lawyers thought they could cut deals, they could do this, but increasingly they realize
it's impossible.
That it is impossible, that we should work together to change the status quo. Now there's an avalanche of petitions, of all these civil society actions and so on. Some of us now take a back seat and look on. Because it is possible to explain to Kasita. Those days the traders would say, when people are demonstrating walk to work, they say they are interfering with our business. When they are pressed, the traders went on strike. Okay? The universities, the students and so on. That's where the action starts.
Yeah.
In the urban areas, with those who have something, who can lose, the civil servants who get sacked from jobs. In my chambers, I always get those. When they are working in government, they don't see anything wrong. The day he's sacked, when he comes, he begins talking. You begin talking to him politics. To say, you see, there's supposed to be a public service commission to hear your grievances. Why is it not working? You can't be on interdiction under the law for more than 6 months. The public service commission is not hearing your case because it is politically constituted. Then he wakes up. Because he had a job, he lost a job. The person who never went to school, who has never lost a job, cannot see these injustices easily. Okay? So you begin by organizing the most intelligent, the most affluent, those who have something to lose immediately. Then you can lift up the rest of society.
And no wonder, you know, the outfit that's leading the Sudan revolution is calling itself the Sudan Professional Association, which is an amalgamation of all the key, the civil service, the lawyers, just as...
Yeah, because they stand to lose their jobs today.
Yeah, exactly.
They stand to have a salary cut. When inflation bites, They are in the money economy.
Yeah.
You see, when inflation bites, the peasant in the village who is surviving on his cassava, who can improvise by putting a distillation of ash to work for sugar, who needs one tablet of soap to wash his one dress in a month, is not affected by inflation the same way you, who has to go to the supermarket every day, every week.
And those are the vast majority of
So
Ugandans.
that peasant, it will take him years to strike over inflation.
But you know, I'm a little bit confused because I'm assessing the two categories that are in our society, and I'm thinking, but wait a minute, the so-called elite that we are talking about, who earn some little money, can put some fuel in their car, go to the supermarket, they're in this comfort, pseudo-comfort mode, yeah? And they will never rise up and do the things that you're talking about and riot because of, you know, inflation prices and so on. And yet the downtrodden are a lot more agitated. It's just that maybe they need a certain leadership to try and organize this, their anger and vitriol. But the guys you're talking about, I don't see how they rise up. They are in a comfort zone on election day. They will sit and recline.
No, actually, you need those
and,
guys, because some of the reasons why those actions have succeeded in Algeria and other countries, they cost money. You need people who can put in some money to sustain those activities, those demonstrations and so on. You need to transport demonstrators, you need to feed them, you need, unless you have business people, civil servants chipping in some money, chipping in inflation. Remember, those people on the streets are not the typical peasant from the village. No. Even the people you see agitating around, artisans, people who work on construction sites who have lost a job because the construction industry is down and so on. Not your typical uneducated, unemployed youth.
So the vendors actually are part of this, the group he's talking about. They are really not, because the people that are not in the money economy, as he used the term, they are actually 69% per the last census by UBOS. These are people who basically grow whatever they grow for subsistence only. They do not interact with money on a daily basis. So if people in Chiseka market are not part of those people, these artisans are actually a very important part of the ecosystem that would potentially read
those are the ones you organize, because any change in economic policy affects them.
Immediately. Fuel prices
affect them, food prices affect them. You know, they may be poor, but they are not the poorest. You know, if somebody is earning 300,000 a month and something threatening to reduce him to 200,000, that person will strike, will riot.
So after this verdict is delivered, the way you are expecting it gets delivered, you know, I'm looking at these categories of people, seeing what they will do. The category you're talking about is going to go on social media, Twitter, make noise and what, you know, call people names, and somehow we shall move on very swiftly.
Yeah, but I think...
No, but that is the category that is in the political parties, the people you want to degenerate. Those are the people moving people power. Those are the people in the student unions. You know, you see the revolution in the universities, how the guild leadership is going and so on. Those are the people who will be reading this judgment and internalizing it.
You know, for me, the key question then is, how come, what has been the biggest hindrance to these groups asserting themselves effectively with success? I think there are several other factors that we need to interrogate in this country, and why it is probably being too optimistic to be excited by Sudan and the other countries. Number one is the role of our military. We are in a militarized state, and as far as I know, currently the leader of this country, the president, has a total grip on the military. The military, as opposed to some of these other countries like Egypt, is not an institutionalized, you know, people actually disobeying orders not to shoot protesters in Egypt and actually joining the people. I'm just imagining what it would take for such a thing to happen in this country. Because here, we do not have an institutionalized military, we have a personalized military. I think what Bashir must be regretting right now in the prison he is in is the mistakes that he made to actually trust some of the other people around him. The generals. That we see Mr. Museveni does not take such chances here. The reason that Mugabe was removed was he allowed Eddie Mnangagwa, one of his comrades from the struggle, to actually also have this mystique and adoration within the military ranks almost equivalent to his, so that the people actually almost thought that they could envision him as an alternative leader. You tell me a person here in Uganda that Museveni has accorded that opportunity. Nobody. If you ask most Ugandans immediately and you ask them if Mr. Museveni is no more, who should? There is almost nobody that comes to mind immediately. People will begin to first fidget. Oh, maybe. They will actually go to his son or his wife. That is a key political astuteness that Mr. Museveni wields over most of the other leaders, long-serving leaders across this continent, that he has almost not allowed any opportunity for an alternative leader to emerge, which means a lot of the people, especially the less sophisticated in the villages, cannot possibly envision someone else right now. And that's a big problem, Council, because people begin their aspirations of resisting by first having assumptions. By the way, I think we need to have someone else.
But there is a blessing in what you've described, which is correct. You see, what President Museveni has done is to destroy the military as an institution. He's not allowed the growth of an institution. So the command is personal. And he treats the military like the snake treats its skin. He keeps shedding off. All the Bushwo comrades, and he shed them off. They may be lying somewhere on Katebe. He may promote Charigonza after so many years. He may promote Kotesa after so many years. But they really are not part of the military. The other day I saw this man, he's been in the land board, General Mugume. These are out of the military, really. The Tumuines, he shed them off long ago. So he keeps getting a new layer, which he tightly controls, of commanders. So the thing is personal. No? You can't, by the way, move 3 soldiers from one unit to another. Even if you are the army commander today, even if you are General Muhoozi, it has to be Museveni himself. So there is no military which can say Museveni should be put aside. The beauty, though, is that should anything happen to Mr. Museveni personally,
God forbid.
God forbid, sickness, incapacity, if you arrested him and held him in Kamikado for 6 hours and there's no command coming from him, the facade that appears as if it is UPDF would just collapse, because he's the Alpha and Omega.
And then what? Anarchy?
Well, it depends on how the forces reconfigure. But the UPDF will disintegrate because it doesn't exist as an institution. If the civilians are organized, they would fill the vacuum and reorganize with elements in the UPDF.
Now my question regarding that, you talk about if the civilians are organized, the civilians,
which he has made difficult, by the way.
How can they perhaps outwit that, even to challenge things like this? Because yes, we go to the Supreme Court, but ultimately it gives you a verdict that is quote unquote anti-people. So how do those civilians get to organize and say, all right, we have tried out the judicial system, it has let us down?
You see, it is a continuous and complicated process. You have to have, first of all, the political position, and they occasionally we try to work together. You get civil society to work together, including the media. It's a tall order, but it's doable. And many times people shout and insult the opposition, but I think right from 1996, the elections of 96, there have been efforts for forces to come together. And these efforts continue. And there's no alternative.
And this is
no
why
alternative. Have to go.
This is why I'm saying that of all of the leaders that we are looking at in the region who have really overstayed their welcome, Mr. Museveni is probably the smartest of them all, because the question you
Is that so? Didn't people think Bashir was very smart?
Well, let me tell you the truth.
Didn't they think, you know,
Because
Mubarak in Egypt was very smart, Ben Ali of Tunisia?
Let me tell you what Museveni has done differently from all of them. Mr. Museveni, throughout his entire history, those who studied him and read him will tell you, he does not underestimate any opposition to him. He basically has this paranoia around him, which has served them quite well, because you see, when you overestimate the threat that you potentially face, it's actually, well, it's a paranoia. Psychologists probably would diagnose you with anxiety, but in the end it's good for you, because that means you basically don't create any margin of error in everything that you do. And that is how he has managed to stay this long. And this is why I always warn people not to be too enthusiastic when they see these things happening in the region. They think they are coming here. Unfortunately, we might have to be waiting longer.
Well, some have said there were more powerful people than himself, but here we are. The justices of the Supreme Court have walked into court. Thank you to my guests. We'll now be crossing over to court to listening to the goings on there.
Numbers 2, 3, and 4 of 2018 polarizing from constitutional petitions numbers 49 of 2017, number 3, 4, 10, and 13 of 2018 between Mare H. Mavili's K. Wanuka, 2 Horn, Karuhanga, Kafureka, Gerard, and 5 others, and Uganda Law Society appearance versus the Attorney General. Respondents.
My Lord, Justice of the Republic of Uganda, my Lords, the Justices of the Supreme Court, my names are William Byaruhanga, and I currently serve as the Attorney General of the Republic of Uganda. And my Lords, I'm appearing together with the Honorable Mwesigwa Rukutana, the Deputy Attorney General, Mr. Francis Atoke, the Solicitor General, Ms. Christine Kawa, the Director of Civil Litigation, Mr. Martin Mwambusha, Commissioner Civil Litigation. My Lords, in the interest of time, I'll supply the names of the other members of my team to the Registrar Secretariat. For the appellants, my Lords, the Honorable Wandera Ogalo appears for the third appellant, together with Joyce Nalunga and Moses Chiemba. Together with them, my Lords, is Fiona Wall, of the Uganda Law Society. My Lords, for the second appellant, represented by Mr. Ladislas Rwakafuzi, the Honorable Kwago Arias, Mr. Chiwanuka Abdallah, Ms. Narukola Ruimbazi, Mr. Narukola Ruimbazi Arias, and for the first appellant, my Lords, Mr. Mare Mavilizi, who represents himself. My Lords, the parties present for the second appellant, we have the Honorable Gerard Karuhanga, the Honorable Jonathan Odur, the Honorable Semujung Nganda, the Honorable Alan Sewanyana, and the Honorable Winnie Kiza. My lords, we are ready to receive the judgment.
Before we deliver the judgment, I want to say a few words to explain why there has been this apparent delay. You may recall that at the last hearing, we reserved judgment to be given a notice. And I did explain even at that time that because of the complex nature of the case, there might be a delay. You know, if you file 30,000 pages of pleadings, it takes a bit of time to plow them through. But there were other issues that affected us because judges also are human beings and we also fall sick. And I was the culprit in that. I had to undergo surgery which kept me off the court for 5 weeks. I was supposed to undergo another surgery for my eyes, which I put off to be able to come and make sure this case is delivered before Easter, so that I can go for my surgery next week. So these are factors that to our being here today not earlier. I call for your indulgence and understanding, but we take our work very seriously and we are now ready to deliver the judgment of the court. I will therefore ask my sister, Lady Justice Stella Rush, to read her judgment.
Thank you, my Lord Chief Justice. I'm not going to deliver the judgment verbatim. It's quite long, so forgive me if I skip some parts. This is my judgment. This consolidated constitutional appeal arises from the decision of the Constitutional Court that sections 1, 3, 4, and 7 of the Constitution Amendment Act number 1, which removed the age limit for the President and chairpersons local council 5 to contest for election to those offices, and for the implementation of the recommendations of the Supreme Court in Presidential Election Petition number 1 of 2016, Mama Mbabazi versus Yoweri Museveni, were passed in full compliance with the Constitution and are valid provisions of the said Act. The decision was by majority of 4-1. This appeal raises very important constitutional issues of great public importance in constitutionalism in Uganda, particularly in respect of the amending power of Parliament. The background. Before considering the merits of the appeal, it is necessary to give a brief background. It's as follows. In September 2017, Honorable Raphael Magezi, Member of Parliament for Igara West constituency in Bushenyi district, moved a motion in Parliament to introduce a private member's bill to amend the Constitution. He was granted leave and he introduced a bill entitled the Constitutional Amendment number 2 Bill of 2017. The object of the said bill was to amend the 1995 Constitution in accordance with Articles 259 and 262 of the Constitution, and it was to provide for the time within which to hold presidential, parliamentary, and local government council elections under Article 61. 2. To provide for eligibility requirements for a person to be elected as president or district chairperson under Articles 102B and 183(2)B. 3. To increase the number of days within which to file and determine a presidential election petition under Article 104, 2 and 3. And 4. To increase the number of days within which the Electoral Commission is required to hold a fresh election where presidential election is nullified under Article 1046. and it also provided for related matters. During the second reading of the bill, when the House was sitting as the committee of the whole House, two separate motions were moved to amend the bill. The first motion, which sought to amend the Constitution by extending the tenure of Parliament and local government councils from 5 to 7 years, was moved by Honourable Michael Usime, MP from Barara Municipality. The second motion, which sought to reinstate the presidential term limits, was moved by Honourable Nandana, MP from Dadil West constituency. After the third reading, Parliament passed the bill as amended. The bill was thereafter sent to assent, and he assented to it on the 27th of December 2010. That bill became law, and it is now Constitutional Amendment Act number 1 of 2018, the subject of this appeal. Some factions of Ugandans, including the appellants, were aggrieved by the passing of the Act and lodged petitions in the Constitutional Court pursuant to Article 137 of the Constitution, challenging the validity of the Act on the ground that the process of enactment, as well as its provisions, had violated the Constitution, and they prayed for its nullification. The petitions were supported by several affidavits. The respondent filed an answer to the petition in which he stated that the Act was enacted in accordance with the Constitution and its provisions were valid and constitutional, and he prayed for dismissal of the petitions. The reply was also supported by a number of affidavits. Since the petitions raised similar issues, the Constitutional Court consolidated them and had them as one. At the hearing, there were a number of issues framed before the Constitutional Court. I will not go through them. At the end of the hearing, the Constitutional Court made the following declaration. 1, and I quote, by unanimous decision, Sections 2, 5, 6, 8, 9, and 10 of the Constitutional Amendment Act 2018, which provide for the extension of the tenure of Parliament and local government councils by 2 years, and for the reinstatement of the presidential term limits, are unconstitutional for contravening the provisions of the Constitution. 2, that accordingly, Sections 2, 5, 6, 8, 9, and 10 of the Constitution Amendment Act 2018 be struck out of the Act. And 3, by majority decision, that Sections 1, 3, 4, and 7 of the Constitution Amendment Act number 1 of 2018, which removed age limits for the President, the chairpersons, local council 5, to contest for election to the respective offices, and for the implementation of the recommendation of the Supreme Court in Presidential Election Petition number 1, have been passed in full compliance with the Constitution, and therefore remain lawful and valid provisions of the Constitution Amendment Act number 1 of 2018. Constitutional Court also awarded professional fees and costs to the petitioners. As indicated earlier, the appellants were aggrieved by the decision, specifically the one in respect of the removal of term limits, and they filed the instant appeals. They filed 3 appeals in this court. The first appeal was filed by Mr. Mabirizi. He filed, his appeal contained 84 grounds. Second one is by the second appellant. The appeal contained 24 grounds. And then the third appeal was by the third appellant. They had 4 grounds. So in total, the appeals were consolidated and then heard as one, and they contained 116 grounds. Now, as I stated earlier, the appeals were consolidated by consent. They were heard together, and the issues agreed for determination by this court were in total 8. I shall be referring to them in the main body of my judgment. The representation was as now. I don't want to repeat them. The same lawyers and Mr. Mabilizi represented himself. I have stated briefly the principles for constitutional interpretation that I will be using as I deal with this appeal. I shall be guided by the following established and well-settled principles of constitutional interpretation that have been guiding our courts in similar appeals. 1. The Constitution is the supreme law of the land and forms the standard upon which all laws are judged. Any law that is inconsistent with or in contravention of the Constitution is null and void to the extent of the inconsistency. 2. The entire Constitution has to be read together as an integrated whole, with no particular provision destroying the other, but rather each sustaining the other. 3. Where words and phrases are clear and unambiguous, they must be given their primary meaning. They must be given their primary, plain, and natural meaning. The language used must be construed in its natural and ordinary sense. 4. In determining the constitutionality of legislation, its purpose and effect must be taken into consideration. 5. A constitutional provision containing a fundamental human right is a permanent provision intended to cater for all times to come, and therefore should be given dynamic, progressive, liberal, and flexible interpretation, keeping in view the ideals of the people, their socioeconomic and political cultural values, so as to extend the benefit to the right to those it is intended for. And 6, the history of the country and the legislative history of the Constitution is relevant and a useful guide. And 7, and most importantly, judicial power is derived from the people and shall be exercised by the courts established under the Constitution in the name of the people and in conformity with the laws and values, norms and aspirations of the people. And the courts shall administer substantive justice without undue regard to technicalities. What are the authorities? Yeah? I will start with the preliminary objection. Before proceeding with determination of the issues raised in the grounds of appeal, it's important to resolve the preliminary objections raised by Mr. Mabilizi and the Attorney General respectively to each other's appeal. I prefer to consider them before going to the merits of the appeal, just in case they dispose of the appeal without going into the merits. Mr. Mabilizi raised an objection to the written submissions of the respondents on the grounds that they had been filed outside the schedule that the court had given the parties at the pre-hearing conference, and we pray that the court should strike them on that account. We considered the objection and found that although it was genuine, this court was to validate such a document under Rule 2, Sub-Rule 2 of the rules of this court in the interest of justice, and we did that. The second, the respondent on his part also raised objections to Mr. appeal, contended that the grounds offended Rule 82 of the Supreme Court rules, in that they were speculative, argumentative, narrative, and insolent, and abuse of the process of court. He also raised another objection to Mr. Mabilizi's appeal, that it did not conform to Article 137 of the Constitution, in that the petition out of which it arose had been filed before the bill had been enacted into an act. And so he prayed that this PO be upheld and Mr. Mabilizi's appeal be struck off. I have considered the arguments of both parties on the preliminary points of law, and I've also considered the relevant laws and authorities referred to both sides. Regarding Rule 82, I find that Mr. Mabilizi's grounds actually offend Rule 82, but using the powers of this court under Rule 2, Sub-Rule 2, I decided that the matter can be overlooked and the appeal should not be struck off. I've given the details of my reasoning. Regarding the complaint about Article 137, I find that Mr. Mabilis' petition fell within the ambit of Article 137 because he filed a petition before, although he filed a petition before the act was passed, he was mainly complaining of the actions that led to the enactment of the act. He was using the small act, not the big act. That is under Article 137. So I overrule the preliminary objections, and I shall move on now to the main issues raised. Now, I started with issue number 7, because again, Mr. Mabilis and Council Kwago raised issues concerning procedural irregularities before the Constitutional Court. And again, if they are upheld, in my view, they would also have an effect on the petitions. So I started with issue number 7, and it was framed as follows. Whether the learned justice of the Constitutional Court derogated the appellant's right to fair hearing and judiciously exercised their discretion and committed the alleged procedural irregularities. There are numerous procedural irregularities that were set out by Council Mabilis and also Council Kwago in their submissions. And this is my decision on issue 7. The complaint in issue 7 concerns 1, alleged derogation of petitioner's right to fair hearing under Article 28 and 44 of the Constitution. 2, alleged injudicious exercise of discretion. And 3, alleged procedural irregularities by the Constitutional Court in hearing and determination of the consolidated petitions. I have perused the transcript of the entire record of proceedings before the Constitutional Court. I have also considered the grounds of appeal as well as the submissions and authorities cited by Council Kwago and Mr. Mabilis. Regarding the allegation of failure to determine the petitions expeditiously, Mr. Mabilis submitted that he filed his petition in December 2017, and the Constitutional Court only heard it in April 2018 in, I quote, a relaxed manner where it could break for weekends starting from Friday to Tuesday. Then the court adjourned from 12 to 17 April for 4 days and says this was illegal. My view is that this allegation is not only unfair to the Constitutional Court, but it cannot be determined fairly without establishing from the Constitutional Court itself the reasons why they scheduled the hearing of the petitions that way. Besides, as the respondent rightly pointed out, court is guided by Article 137, Clause 7 of the Constitution, which provides, and I quote, upon a petition being made or a question being referred under this article, the Court of Appeal shall proceed to hear and determine the petition as soon as possible, and may, for that purpose, suspend any other matter pending before it. In my view, as soon as possible depends on the court's workload and schedule, and I take judicial notice of the fact that the Constitutional Court is among the courts in this country with a huge case backlog due to inadequate resource allocation by government. The backlog comprises constitutional petitions as well. In such a situation, Mr. Mabilis would be expecting too much from the courts to determine his petition immediately it was filed, regardless of other constitutional petitions that would be pending before that court. That is why the framers of the Constitution used the expression as soon as possible. It is noteworthy that Mr. Mabilis equates his petition to presidential election petitions, which are given specific timelines under the Presidential Elections Act. The authorities cited are, for this reason, inapplicable to his petition. Most importantly, I take note of the fact that the court was faced with a very complex matter involving at least 9 petitions with voluminous documents and pleadings that required the court to peruse in order to prepare for the hearing. This included authorities cited by the petitioners Specifically, Mr. Mabirizi, who stated in this court that he filed a total of 60 authorities before the Constitutional Court. This would inevitably necessitate a lot of reading and research by the learned justices of the court, which could not be accomplished within a short time. The same reason applies to the failure to deliver the judgment within the 60 days. Most importantly, it should be noted that the 60 days requirement is not mandatory. The Uganda Code of Judicial Conduct is simply a set of principles and rules that were adopted by judicial officers to provide guidance in their judicial conduct. Failure to comply with it is not fatal to the judgment. The rule says, where judgment is reserved, it should be delivered within 60 days, unless for good reason it is not possible to do so. End of quote. Mr. Mabirizi never inquired from the Constitutional Court whether it had no good reason why the judgment was delivered outside the 60 days. There is also no law cited by Mr. Mabirizi that had been violated by the court. The period must be taken in context. In most jurisdictions, cases take more than 6 months. For these reasons, I find this complaint had no basis. Mr. Mabirizi's complaint that he was evicted from the seat of the court also lacked merit in my view. It's a notorious fact that Mr. Mabirizi is a law graduate who has not yet been called to the bar since he has not yet acquired the postgraduate diploma in legal practice that is required for his enrollment. He cannot therefore practice law from the bar alongside other counsel with requisite qualifications. That is why the Constitutional Court advised him to sit where the rest of the petitioners were seated. It should be noted that Mr. Mabirizi was given a separate desk and seat away from the bar, even in this court. What is most important is that he was able to present his petition without suffering any prejudice as a result of the seating arrangement. The allegation that he was not given ample time to present his case is unsubstantiated. He did not elaborate on how much time he needed to present his case and how much of his case, if any, was left out by the court. It is also not on record that he asked for more time and the court refused his request. The allegation that the court turned into defense counsel and even suggested answers was not substantiated again. Regarding the denial to make a rejoinder, I find that all parties were given equal opportunity to present their respective cases. This was after the court had, from the outset, set out the ground rules on how the consolidated petitions should be heard. And this is accepted practice in modern case management, where the judges are expected to be proactive. I also find that all the appellants were given an opportunity to make rejoinders before closing their cases. And Mr. Mabirizi actually did so at page 2231 of the record of proceedings. The Deputy Chief Justice might have used the wrong term when he referred to it as closing remarks, but those were actually rejoinders. The Constitutional Court did not contravene any of the international conventions as alleged. The court had the discretion to deal with the petition in accordance with the rules of procedure, and it did precisely that. I have perused the judgments of the 5 justices of the Constitutional Court. It is crystal clear that the judgments were based on the pleadings, the affidavit evidence, as well as the submissions, including the authorities relied on by the parties. The fact that the justices did not specifically mention all of them does not mean that they never took them into account in arriving at their decision. It's a question of style. I also find that the justices determined all the issues that had been framed and agreed upon by the parties for determination by that court. The legality of the affidavits of Mr. Mwakaniza and General Muhoozi were not an issue. Even so, both officials had sworn the said affidavits in their capacities as the highest technical officers in the UPDF and the Ministry of Finance, respectively. The allegations were against the UPDF and the Ministry of Finance. Musoke, Justice of the Constitutional Court, rightly found out that the affidavits in question did not contain any hearsay and declined to strike them out. I I also find that the allegations that the DCJ was covering up the affidavit of General Mhozi is baseless. I have checked the record and I find that the affidavit was sworn on the 29th of March 2018 before one Annette Okwera, Commissioner for Oaths. Regarding the issue of cross-examination, I note that the witnesses were cross-examined with leave of court. I note that the court gave leave on condition that counsel would confine the cross-examination to the areas that were covered in the affidavits of the respective witnesses. I am aware of the requirement under Section 137 of the Evidence Act, but it does not apply in such circumstances. The section applies where the evidence is given orally in court. As for the remedy of severance, I agree with counsel for the respondent that it need not have been pleaded. Article 137(4) empowers the Constitutional Court to, and I quote, A, grant an order of redress, and severance was an order of redress. Regarding the failure to give reasons for dismissing his application to summon the Speaker for cross-examination, I find from the record that Nakuru, Justice of the Constitutional Court, who delivered the ruling on that said application, actually gave a reason for dismissal to the effect that the court had not found any reason to do so. He, however, added that the court would give a detailed reason later on in the judgment. Unfortunately, the court, most likely through an oversight, did not do so. This was an error on the part of the court. The issue is, however, moot now since the Supreme Court dismissed application number 7 of 2018 for a similar request on the 14th of December 2018. The requests for the other officials were not made by both Mabirizi and counsel for the second appellant. The Constitutional Court cannot be blamed for failure to summon them. Perhaps as argued by the respondent, the court was satisfied that the evidence availed, particularly the answered, together with the certificate of financial implication as well as the certificate of compliance by the Speaker, would suffice in the circumstances. Regarding the alleged injudicious exercise of discretion, particularly with regard to the professional fees and denial of professional compensation to Mr. Mabirizi, it is well settled that an appellate court can only interfere with the exercise of discretion by a court of original jurisdiction where, and I quote, 1, where the judge misdirects himself with regard to the principles governing the exercise of his discretion. 2, where the judge takes into account matters that he ought not to consider or fails to take into account matters that he ought to consider. 3, where the exercise of discretion is plainly wrong. And I've cited the authorities there. These awards were purely discretionary, and the appellants have not proved that the justices misdirected themselves on the principles regarding the award. This court will not therefore interfere with it. The same reason applies to the complaints by the second appellants. In conclusion, I agree with the respondent that the procedure adopted by the Constitutional Court was entirely within its discretion and did not in any way prejudice the appellant or occasion any derogation of his or their rights to fair hearing. All the appellants participated at each and every stage of the proceedings and received a fair hearing in accordance with Article 28 of the Constitution. The appellants have not proved the respective grounds set out herein, and they accordingly failed. Issue 7B says, if so, what is the effect on the decision of the court? In light of my findings on issue 7A, this issue does not arise. Now I go to issues 1 and 5. Issue 1 is as follows. Whether the learned justices of the Constitutional Court misdirected themselves on the application of the basic structure doctrine. Issue 5. Whether the learned majority justices misdirected themselves when they held that Constitutional Amendment Act No. 1 of 2018 on the removal of age limit for the presidential and local council 5 offices was not inconsistent with the 1995 Constitution. The issues before the Constitutional Court were as follows. 6G, whether the act was against the structure of the spirit and the structure of the Constitution. And issue 12 was whether sections 3 and 7 of the act were inconsistent or in contravention of articles 21, 3 and 5 of the Constitution. The Constitutional Court answered issue 6G in the affirmative in respect of sections 2, 5, 6, 8 and 10 of the act, and they answered it in the negative in respect of sections 1, 3, 4 and 7 of the act. Issue 12, they answered it unanimously. I shall not go through the submissions of counsel. I'll go to the consideration of these two grounds. The learned justices of the Constitutional Court gave a detailed history of the basic structure doctrine in their judgment. I do not intend to repeat them, but let me briefly summarize the essence of the basic structure doctrine in this judgment as I understand it. The basic structure doctrine is a judicial principle that the Constitution has certain basic features that cannot be altered or destroyed through amendments by Parliament in exercise of its legislative powers. These features are considered to be fundamental principles that give identity to the Constitution. They are intended to subsist forever to enable the continued existence and legitimacy of a country, and therefore it cannot be amended in a way which would destroy the indestructible character of the Constitution. The doctrine was introduced by the Supreme Court of India as a limitation on the power of Parliament and a measure against arbitrary exercise of the power of Parliament so that it would not freely amend the Constitution. It became pronounced in India following the case of Kasavananda Bharati versus State of Kerala, which imposed limitations upon the amendment power of Parliament in amending the Constitution in as far as certain features of the Constitution were concerned. And the court held, and I quote, according to the doctrine, the amendment power of Parliament is not unlimited. Rather, it does not include the power to abrogate or change the identity of the Constitution or its basic structure, basic features. End of quote. This doctrine was affirmed by Professor Konrad Dietrich, a German jurist. It has since influenced the constitutional jurisprudence in several other jurisdictions across the globe, including Taiwan, India, South Africa, Kenya, and so on. In all these cases, it is generally established that there are certain features of the constitutional order that are so fundamental and form the foundation of the Constitution, and therefore cannot be changed by Parliament even if it followed the necessary amendment process. The doctrine is still in its nascent stage. In some countries like Tanzania, it was not accepted for the reason that the Constitution of Tanzania does not contain provisions that cannot be amended, and I quote that decision. There is no hard and fast rule in determining the basic structure of a given constitution. This is determined on a case-by-case basis. Over time, the courts have taken into account the historical background, the preamble, and the entire scheme of the Constitution in determining these issues. Various courts have identified certain constitutional core or set of basic constitutional principles that form the constitutional identity, which cannot be abrogated through the constitution amendment process. It is widely believed that they include the supremacy of the Constitution, democracy, federalism, independence of the judiciary, secularism, human dignity, sovereignty of the people, separation of powers, and rule of law, among others. Now, in the Constitutional Court, the learned justices rightly recognize the fact that this doctrine is embedded in our Constitution, and while determining this basic structure of this country, the learned justices were guided by our constitutional history, our constitutional structure, political changes, the preamble, and the national vision of this country. I quote what the learned Deputy Chief Justice observed, and I also reproduce what Justice Kasule observed, Justice Chiborion, Justice Musoke. In summary, the learned justices observed that the basic structures of our Constitution include the following: the national objectives and directive principles of state policy, sovereignty of the people, the Constitution as the supreme legal instrument, democratic governance and practices, a unitary state, separation of powers between the executive, parliament, and the judiciary, Bill of Rights, ensuring respect for the observance of fundamental rights, and judicial independence, and the preamble. Justice Kakuru, in his dissent, has also highlighted a list that he considers to be the basic structure of our country, and I reproduce it. I have quoted extensively from the judgments of the Justice of the Constitutional Court to determine how each of them resolved this issue. I find that they have brought out clearly what constitutes the basic structure of the 1995 Constitution of Uganda. In my view, the owners of the Constitution are the people of Uganda under Article 101 of the Constitution, which says that all power belongs to the people, who shall exercise their sovereignty in accordance with the Constitution. While constitutions are intended to be both foundational and enduring, they are not intended to be immutable. If they are to endure, they must respond to the changing needs and circumstances of a country. To evolve and change with all the changes in society and environment, it is necessary for every constitution. The 1995 Constitution was as a result of an elaborate and highly detailed constitution-making process that involved all citizens. The framers of the Constitution did not, in my view, perceive the Constitution as an eternal document that could not be amended in any way. They were alive to the fact that the law was dynamic and could change with the changing society. It is for this reason that they provided for a methodology which is either rigid or flexible for amending the Constitution in two folds. A, amending the Constitution through the participation of the people, that is through a referendum, and B, amending the Constitution through the people's representative, that is through Parliament. The rationale for the foregoing was to put checks and balances and ensure that the will of the people is not interfered with at will by their elected leaders. It is for this reason that the Constitution, to an extent, has a basic structure to act as a check on parliamentary power, so that the Constitution does not become a plaything in the hands of Parliament, which is a delegate of the real sovereign, namely the people. Its power to amend can be exercised only without disturbing the balance between the rights conferred on the people and the legislative power of the state. Although the basic structure doctrine envisages that certain basic features cannot be changed, our Constitution is unique. It expressly provides under Article 255 and 260 for how basic features can be amended or altered. This is through the participation of citizens by way of a referendum and the support by not less than 2/3 of members of Parliament. Parliament on its own does not possess the mandate to make an amendment to such provisions without the will of the people through referendum. This is in line with the recommendations by the Odeko Commission in its report in respect of amendments of the core features which were adopted in the 1995 Constitution, and I have reproduced it in this judgment. I would therefore adopt the above observations by the learned justices of the Supreme Court of the Constitutional Court as to what constitutes the basic structure of our Constitution, including the ones of Justice Kakuru, as all those stem from Articles 1 and 2 of the Constitution. The basic structure having been enshrined by the people themselves, then it is the people themselves to alter the identity of the Constitution. This is by way of referendum. The issue therefore is whether Article 102B forms the basic structure, and Parliament did not have the mandate to amend it in the manner it did. All the learned justices held that Article 102B does not form part of the basic structure, and therefore Parliament can amend it using its powers and the procedure set out in Chapter 18 of the Constitution. I will produce the holding by the Deputy Chief Justice, the holding by Justice Kasure, the holding by Justice Cheborion, holding by Justice Musoke, and Justice Akuru. I'm in agreement with their lordships that the qualifications of the President do not form part of the basic structure, that amending them would change the identity or destroy the basic features of the Constitution, and therefore cannot be amended by Parliament following the constitutional process. In my opinion, in interpreting the Constitution, I find that Article 102B is not among the entrenched provisions, that amending it would be contrary to the provisions of the Constitution, or that the identity of the Constitution would be destroyed. In conclusion, therefore, I share the opinion of the learned justices of the court that amending Article 102B does not emasculate the preamble or destroy the basic features of the Constitution, since the people still retain the sovereignty to democratic governance and freely choose who they want to lead them for a specified period, in case one-term limit, or in this case for a period, if they still want the incumbent to rule them. Accordingly, answer issue number 1 and 5 in the negative. They fail. I go to issue number 2, which was framed as follows: whether the learned justices of the Constitutional Court erred in law and in fact in holding that the entire process of conceptualizing, consulting, debating, and enactment of the Constitution Amendment Act number 1 of 2018 did not in any respect contravene, nor was it inconsistent with the 1995 Constitution of the Republic of Uganda and the rules of procedure. Land Council submitted at length on these issues. I shall not reproduce their submissions. I'll go straight away to consideration of the issues raised. Before I consider the issue, I set out the process required, the legislative process required for passing the private member's bill. I shall not read it out. It is quite elaborate, and I also stated that in case of a constitutional amendment, it's also governed by Chapter 18 of the Constitution. The first complaint under issue 2 is non-compliance with Article 93 of the Constitution. I set out the complaints and the submissions of counsel, and this is my decision. Article 93 reads as follows, and I quote: restriction on financial matters. Parliament shall not, unless the bill or the motion is introduced on behalf of government, A, proceed upon a bill, including an amendment bill, that makes provision for any of the following. 1. The imposition of taxation or the alteration of taxation, otherwise by reduction. 2. The imposition of a charge on the consolidated fund or other public fund of Uganda, or the alteration of any such charge otherwise than by reduction. 3. The payment, issue, or withdrawal from the consolidated fund or other public fund of Uganda of any monies not charged on that fund, or any increase in the amount of that payment, issue, or withdrawal. 4. The composition or remission of any debt due to the government of Uganda. And 5. And B. Proceed upon a motion including an amendment to a motion, the effect of which would be to make provision for any of the purposes specified in paragraph A of this article. End of quote. The It is clear that Article 93 of the Constitution bars Parliament from proceeding on either a bill or a motion unless the bill or motion is introduced on behalf of government in specific cases, which include A, the imposition of a charge on the consolidated fund or any other public fund of Uganda, or the alteration of such fund other than by reduction. This means that although a member of parliament has the right to move a private member's bill under Article 94, 4b, Parliament is barred from proceeding on a private member's bill under Article 3 if the bill has a provision or provisions that would lead to the imposition of a charge on the consolidated fund or any other public fund of Uganda, or the alteration of such fund other than by reduction. For instance, a bill for the construction of a university or a hospital. My opinion is that in determining whether or not the provisions of a bill would lead to an imposition of a charge on the consolidated fund, one would consider the content of the bill and not the process of the bill. How does Parliament determine that a bill complies with Article 93? Although Rule 123 of the Rules of Parliament, of the new rules, provide that it is the Speaker who should give an opinion regarding financial matters in respect of private members' bill, in practice, this is the responsibility of the Minister of Finance, who is expected to be the expert in this field. It is determined by looking at the provisions of the bill right from the inception. Rule 107 of the 2012 Rules of Procedure of Parliament, under which the impugned bill was introduced by Honourable Magezi in Parliament, provided that, and I quote, 1. All bills shall be accompanied by a certificate of financial implication setting out the specific outputs and outcomes of the bill. B. How those outputs and outcomes fit in the overall policies and programs of government. C. The costs involved and their impact on the budget. D. The proposed or existing methods of financing the costs related to the bill and its feasibility. And 2. The certificate of financial implications shall be signed by the minister responsible for finance. End of quote. In the case before court, the record shows that on the 27th of September 2017, Honourable Magezi sought leave to introduce a private member's bill, and Parliament gave him permission to do so. The record further shows that the bill that Honourable Magezi introduced was accompanied by a certificate of financial implication dated the 28th September 2017. It is certified that the bill entitled the Constitution Amendment Bill 2017 has been examined as required under Section 76 of the Public Finance Management Act of 2015 as amended. It reported in the relevant part that, and I quote, E. There are no additional financial obligations beyond what is in the medium-term expenditure framework, and thus the bill is budget neutral. End of quote. The certificate was signed by Honourable Matia Kasaija, Minister of Finance, Planning and Economic Development. On the 3rd of October 2017, the bill was tabled for the first reading, after which it was sent to the Legal and Parliamentary Affairs Committee for scrutiny. The committee scrutinized the bill in detail and interacted with and received memoranda from a number of stakeholders. On the 18th December 2017, the committee submitted its report to Parliament, and the Constitutional Amendment Number 2 Bill of 2017 was given a second reading, where its merits and principles were debated. During the presentation of the report, the chairperson of the Legal and Parliamentary Committee pointed out that in the report that some members had expressed the wish to introduce some amendments to reintroduce term limits and to extend the term of the president to 7 years. The committee reflected in its report and indicated that, and I quote, the committee is agreeable to the proposed amendment, but note that it is a requirement in the Constitution for each decision expanding the term of office of president beyond 5 years to be subjected to referendum of the people. The committee therefore recommends that the term of office of the president be extended 7 years, but the legal processes described by the Constitution pursuant to which such amendment can be legally made may be complied with. End of quote. A vote was taken on the second reading. There were 2 abstentions, 97 against 317 in favor. The bill was then committed to the Committee of the Whole House for consideration, clause by clause. It was during this stage that Honorable Sime and Honorable Mandala introduced 2 amendments extending the term of Parliament to 7 years and reinstating the term limits for the President. The amendments were in Article 77, 181, 29, 291, 105, and 26 of the Constitution. They were later contained in sections 2, 5, 6, 8, and 9 and 10 of the Act. These amendments called for a referendum and therefore posed a charge in the Consolidated Fund. On the premises, I share the opinion of the learned justices of the Constitutional Court that the introduction of the new clauses, given that they required a referendum, which in essence would increase and strain the government expenditure, had an effect of creating a charge on the Consolidated Fund, and therefore Parliament ought not to have proceeded on these amendments. In my opinion, the amendments were null and void ab initio and had no consequence. As the majority justices of the Constitutional Court rightly found, in my view, these amendments contravened Article 93 of the Constitution and rightly applied Article 2, Sub-Article 2 of the Constitution and severed them from the Majesty Bill. Regarding the issue of the 29 million given as facilitation to the members of Parliament, in my view, this did not create a charge on the Consolidated Fund, since the evidence showed that this money had been appropriated by the Parliamentary Commission. For this reason, I find that issue 6A was rightly answered in the negative by the Justice of the Constitutional Court. Likewise, with respect to issue 6B, I find that the passing of sections 2, 5, 6, 8, and 10 of the Act was inconsistent and in contravention of Article 93. This issue was rightly answered in the affirmative. In the circumstances, I find that the learned justices were right to apply the doctrine of severance to expunge the invalid sections from the Act. And then I discuss the doctrine of severance, and I don't need to go through it. So in my view, since the process of enacting the Honorable Majesty's Bill into law was passed in accordance with the law, left to stand alone, it is not substantially altered. It reflects the intention of the maker in its purpose, operation, and effect. The principle of severance, in my view, therefore applies in the circumstances. Since the new clauses introduced in the bill during the committee stage were not passed in accordance with the Constitution, they were invalid, and the justices were right to apply the principle to sever the clauses from the bill. So this issue also fails. The next issue is smuggling the Magezi motion on the order paper. And this is my decision. According to the answer on the 27th of September 2017, the Speaker decided to amend the order paper and to include motions on amendments of the Constitution due to failure by the government to present to the House comprehensive amendments. She highlighted notices of motions for leave to introduce private members' bills that had met the criteria in Rule 47 for inclusion in the day's order paper. These included the motion brought by Honorable Magezi with a bill attached. There was another motion by Dr. Sam Lunoki with also a bill attached, and then the other by Honorable Kasamba did not have a bill attached. The Speaker informed the House that the reason why she had considered the Magezi motion first was that under the rules, bills take priority over motions. In my opinion, Articles 94 read together with Rule 24 and 165 of the 2012 rules are clear that the Speaker shall determine the order of business in the House. Further, Rule 7, Sub-Rule 2 and Sub-Rule 3 give the Speaker general authority to decide questions of order and practice, stating the reasons for her decision. Rule 8 is to the effect that in case of any doubt and for any questions of procedure not provided for in the rules, the Speaker shall decide. In my opinion, in the above laws, the Speaker had the discretion to amend the order paper and to determine the order of business in Parliament. Further, I find that the Speaker's reasoning for allowing the motion before the Magezi motion before the Nsamba motion was not unconstitutional. First, she had the authority to determine the order of business. Secondly, Nsamba's motion was not a bill but a resolution of Parliament urging government to constitute a constitutional review commission. The Magezi motion had a bill attached, and according to the order of business of Parliament, although they both met the criteria in Rule 47 of the 2012 rules, bills take priority, which is reflected in Rule 24. The Hansard further shows that at the time of moving the motions for leave, neither Nsamba nor his seconder was available. However, having amended the order paper, the Speaker ought to have sent the same to members at least 3 hours before the sitting, as required by Rule 26(1)(b). Failure to comply with this rule, in my view, was an irregularity, but it does not amount to a violation of the Constitution that would lead to the nullification of the Act. So in summary, on this issue, I find that the Speaker had the power to amend the order paper. The Constitution provides that she is in charge of the Parliament. The rules were made by Parliament, and the Business Committee is a creature of the rules. Therefore, it will be unduly interfering with the internal workings of Parliament by this court, which would also be unconstitutional in view of the doctrine of separation of powers. This issue fails for that reason. Denial of access to Parliament. Denial of access to Parliament to members of the public. I have considered this complaint. Rule 22 sub-rule 1 and 23 sub-rule 1 provides, and I quote, sittings of the House to the public. Subject to these rules, the sittings of the House or its committee shall be public. However, under Rule 219, which is now 230, the authority to admit the public in the pressings of Parliament rests in the Speaker, and I quote the rule. It is common ground that there was a lot of tension in Parliament during that period. This necessitated extra precaution on the part of the Speaker and the parliamentary staff. Therefore, the Speaker acted within the Constitution and the rules in directing that the members of public were screened to ensure security of Parliament during the enactment of the bill. It is of course not entirely true that the members of the public were denied access to Parliament on the day Magezi moved the motion to introduce the bill. The answer indicates that on the 26th September 2017, the Speaker acknowledged the presence of a number of people, including a delegation from the Parliament of Sierra Leone. On the 27th of September 2017, the answer reports the presence of a number of people in the VIP gallery, including members of Parliament, former members of Parliament, Alaso, Ikwao, and so on. In my judgment, therefore, I find that although Mr. Mabilisi has proved that he was denied access to the gallery on that day, it was within the Speaker's powers under Rule 230. I also find no proof of the allegation that members of the public were denied access to the gallery during that period. I answer this issue in the negative. The next issue is tabling Constitutional Bill number 2 of 2017 in Parliament in the absence of the leaders of opposition, the opposition chief whip, and other opposition members of Parliament. I reproduce the holdings of the land justices of the Constitutional Court on this issue, including the Deputy Chief Justice, Justice Kasule, and in my view, Rule 24.1, which provides that the quorum of Parliament shall be 1/3 of all members of Parliament who are entitled to vote, applies. Sub-Rule 2 provides that the quorum is required only when Parliament is voting on a question. Not only does Rule 24 allow the business of Parliament to continue in the absence of some members, but still, the appellant did not produce evidence that Parliament lacked quorum when they were voting on any question. No reason was given for the absence of the leaders of the opposition, the chief whip and other opposition members of Parliament from Parliament on that day when the bill was tabled. The evidence on record shows that they actually walked out of Parliament voluntarily. There is also no complaint that there was no quorum on that day. According to the Hansard, they later returned to the House and participated in the debate of the bill. The allegation of the violation of the Constitution is accordingly not made out. I therefore agree with the planned justices of the Constitutional Court that the act of tabling the said bill in their absence was not unconstitutional and did not breach the rules of procedure. I find no merit on this issue as well. The next one is the Speaker permitting members of Parliament from the ruling party to sit on the opposite side. I have also considered this issue. Rule 9 of the Rules of Parliament sets out the sitting arrangement of Parliament. Rule 7 and 9 of the rules give the Speaker the power, depending on the circumstance, to allow members to sit, to allow members of Parliament to sit in particular seats reserved for them. There was no evidence that the honourable members of Parliament were prejudiced in any way when she permitted them to sit as indicated. There is no evidence that the order was. There is evidence that the order was temporary, and thereafter, when the opposition members of Parliament returned to the House, they were able to occupy their seats comfortably. There is no evidence on record that this order of the Speaker had an impact on the process of enacting the Act. I find the allegation that the act of the Speaker complained about violated the Constitution was not proved by the appellant. This issue also failed. The fifth complaint is signing of the committee report by non-members of the committee. I set out the submissions and the findings of the justice of the Constitutional Court, and this is my ruling on this issue. It was established that some members who joined the committee at a later stage had signed the report, although they did not participate in the proceedings before the committee. This was irregular but not unconstitutional because Article 94(3) of the Constitution provides as follows, and I quote, "The presence and participation of a person not entitled to be present or to participate in the proceedings of Parliament shall not by itself invalidate those proceedings. The signature of the members in question could not invalidate the report of the committee." So I answer this question in the negative, and I give more detailed reasons. The next issue is the Speaker's action of suspending 6 members of Parliament. I have also considered this issue. The Constitutional Court found that the suspended members had defied the Speaker and disrupted the proceedings in the House. Her action to suspend them was therefore justified. There was no evidence that she acted or traversed the rules permitting her to take disciplinary action to maintain the honor of the House. There was further no evidence of a substantive motion to question her decision. There was necessary quorum for debate in the second and third reading, and therefore the suspension did not make the enactment of the Act unconstitutional. I have given reasons for my decision, and I agree with the findings of the justices of the Constitutional Court on this ground as well. The next ground is non-compliance with the requirement of the 3 sitting days. I have also considered the submissions and the rules that were referred to. I agree with the majority this ground should also fail. The next ground is violation of the requirement of the 14 sitting days between the second and third readings. In view of my findings, I agree with the Land Justice of the Constitutional Court that this rule applies to the amendments that required a referendum, and the emergency bill did not require a referendum. So I find no merit in this issue. The next issue is closing the doors of Parliament during debate. Under this issue, I also agree with the Constitutional Court that it should fail. I have reproduced their reasonings verbatim. I've also analyzed the circumstances under which the Speaker allowed the voting to take place when the door was not closed. So I agree with the non-justice of the Constitutional Court. The next issue is the question of violence. The issue of violence was canvassed under issue number 3. It was framed as follows: whether the learned justices of the Constitutional Court erred in law and fact when they held that the violence scuffle inside and outside Parliament during the enactment of the Act did not in any respect contravene or was inconsistent with the Constitution of the Republic of Uganda. I have produced the submissions of counsel on this issue before the Constitutional Court and before this court, and this is my view. Violence inside Parliament. According to the evidence on record, there were events that occurred during the proceedings of the 21st, 26th, and 27th September. Witnesses stated the Speaker to use her discretion and maintain order and decorum in the House as required under Rule 7 sub-Rule 2 of the Parliament's Rules of Procedure. In so doing, under Rules 77, 79, 2, and 80, the Speaker suspended 25 members who had adamantly refused to exit the House despite her orders. I have quoted the clerk to Parliament and Hamid Kagoy, the Sergeant at Arms, and according to the Hansard, the Speaker had made calls to Parliament to maintain order and decorum. To be evicted. Justifying action and I quote, where a member who has been suspended from the service of the House refuses the Speaker when summoned under the Speaker's orders by the Sergeant at Arms to obey such direction, the Speaker shall to compel obedience to his or her direction, and the Sergeant at Arms shall be called upon to eject the member from the House. End of quote. I note, however, that in the process of evicting the said members from the House, some unknown persons brutally beat up some of the members, including those who were not suspended, thus causing some members were also arrested. This led to the Speaker to inquire from the President in her letter dated 23rd October 2017 about the invasion of Parliament by security agencies on the 27th September 2017. From the foregoing, I agree with the Justice of the Constitutional Court that the violence was caused by members of Parliament themselves as a result of lack of decorum on their part. In the case of Tino Businje Severino versus Attorney General, the Constitutional Court observed, and I quote, Although members of parliament are independent and have the freedom to say anything on the floor of the House, they are, however, obliged to exercise and enjoy their powers and privileges with restraint and decorum, in a manner that gives honor and admiration, not only to the institution of parliament, but also to those who inter alia elected them, those who listen to and watch them debating in the public gallery and on television and read about them in the print media. As the national legislature, Parliament is the fountain of constitutionalism, and therefore the honourable members of Parliament are enjoined by virtue of their office to observe and adhere to the basic tenets of the Constitution in deliberations and actions. End of quote. This was further emphasized by the Honourable Deputy Speaker in his address to the House in the proceedings of the 21st September, when he emphasized, and I quote, "The hallmark of a parliament is courtesy among and between members. So please let us not do things that will cause unnecessary anxiety in the House." End of quote. That notwithstanding, I note that in bringing calmness in the House, there was also violence caused by the invasion of security agencies, as indicated in the Speaker's letter. The affidavits of Honorable Betty Namboze, Honorable Muyagwa, Honorable Karuhanga, Honorable Dur, Jonathan, and Honorable Sewanyana all show that they were brutally tortured and treated inhumanly, causing injury to them, which acts were unconstitutional. The respondent relied on the affidavit evidence of General David Muhozi, where he stated that under Article 209B of the Constitution, the UPDF can ensure civil public compliance, and in that regard, the UPDF has supported the Parliament Police in ensuring peace and harmony. I quote that article, and I say that even if the presence of the UPDF was justified, excessive and unwarranted force was not required in the circumstances. I find that the acts were contrary to Articles 2, not Articles 23 and 24 of the Constitution. In such circumstances, in my view, the appropriate court, if the affected members wish to seek redress for enforcement of their rights, would be the High Court, which is mandated to investigate and determine the appropriate redress as per Article 50 and 137 of the Constitution. In conclusion, I agree with the learned justice that even if there was violence inside Parliament on the said date, it did not vitiate the enactment process. The scaffold took place before Honorable Magezi had moved his motion for leave to introduce the bill under Article 94B, and thereafter, there is no evidence adduced by the appellants that the subsequent proceedings were interfered with by security agencies in order to vitiate the process, or that there was a chilling effect on members debating the bill. The bill was debated and supported at the second and third reading by the votes of not less than 2/3 of all members of Parliament. Article 162 was observed, and subsequently the bill was passed according as per Article 259 of the Constitution. Violence outside. There is evidence that in the process of carrying out the directive of the Assistant Inspector General of Police, Mugenyi, restricting the members of Parliament within their constituencies, and in some places rallies were disrupted. This contravened Article 29 of the Constitution. However, there is evidence that in other places rallies took place as rightly found by the Constitutional Court. This did not vitiate the enactment of the process, since the members reported during the debate that they had consulted and they were therefore reporting the views of the public. Article 3, sub-Article 2 of the Constitution was misconstrued. The vote of the majority of the members of Parliament who fully voted over and against the amendments. I therefore find no merit on this issue. Issue number 4 concerns the use of the substantiality test. I have considered the submissions of counsel. I agree that the land justices erroneously applied the substantiality test to this case, The test which they applies to presidential and parliamentary election petitions, and also the jurisprudence which they applies to presidential and election petitions. Although this is a tool of evaluation, the learned, as I said, the learned justices erred when they applied it to the constitutional matter. For this reason, I answer this issue in the affirmative. Issue number 5 is concerns the removal of the age limit. I've already dealt with it when I was discussing issue number 1. Issue number 6 is as follows: whether the Constitutional Court erred in law and in fact in holding that the president elected in 2016 is not liable to vacate office on attaining the age of 75 years. I have considered the submissions and also the ruling of the Constitutional Court. I agree with the justice of the Constitutional Court that this issue should fail. I've said that the words used in Article 83, 1B and 102 are plain and ought to be given their natural meaning. Article 83 applies to the tenure of members of Parliament, not to the President. The requirement of age as a qualification for being elected President is at the point of election and not during the incumbency. The framers of the Constitution would have expressly stated so had they intended that the President should vacate office upon attaining the age of 75. I therefore find no merit in the submission of the appellant on this issue. So that brings me to the final issue, which is issue 8. Issue 8 was what remedies are available to the parties. For the reasons I've given herein, I would dismiss the appeal, the consolidated appeal, and the parties shall bear their costs in this court. I would confirm the decision of the Constitutional Court. Before I take leave of this matter, I wish to express my gratitude to Mr. Mabilizi and Council for all the parties, for the industry and zeal they put in the preparation and presentation of this case. This is the end of my judgment. It's dated and delivered at Kampala this 18th day of April 2019, and I've signed it in front of all of you.
I want to thank my grand sister for her judgment. I will now invite my grand brother, Justice Mwangusia, to read his judgment.
My Lord Chief Justice, like my sister, I don't think it is feasible to go through this heap of judgment, so I will only pick out the salient, what I think are the salient points in the judgment. The judgment sets out the background, the issues raised at the Constitutional Court, all the grounds raised in this court by all the appellants, and the rule, the principles of constitutional interpretation. I will also start by dealing with the preliminary objection, then issue 7, because issue 7 can dispose of this appeal if we found that the Constitutional Court did not follow the procedure, and therefore the entire trial and judgment were null and void. I set out the submissions on the preliminary point raised by the Attorney General, and this is my say about it. I agree with the Attorney General that for the reasons he so ably expounds, the appearance memorandum of appeal does not meet the standards set out under Rules 82 of the rules of this court. However, as rightly pointed out by the appellant, the preliminary point should have been raised at the earliest opportunity. which was at the pre-hearing conference, when, apart from consolidating the appeals, issues arising from all the memorandum of appeal, including the one of the appellant, were framed. After framing the issues, court allowed parties to file written submissions, which the parties, including the appellant, complied with. Having allowed the appellant to proceed with the appeal, this court cannot strike it out at this stage of the hearing, and as rightly pointed out by him, the Attorney General would not suffer any prejudice. I also deal with the bit about the cause of action, and I found that under Article 137, sub-articles clause 3, the appellant's petition raised a cause of action. Now, I also set down all the issues raised for determination by this court. And from time to time, I'll be repeating them for each issue. I'll be stating it and then resolving it. Issue 7 was framed as follows. A, whether the land justice of the Constitutional Court derogated the appellant's right to a fair hearing and judiciously exercised their discretion and committed the alleged procedural irregularities, and if so, what is the effect of the decision of the court? I set out all the submissions in summary. All the submissions by the parties are set out in this document. Now, I deal with all the issues raised, but I think I'll pick out two or three, which I think are pertinent for future trials. The first one is the failure to summon the Speaker. Both here and at the Constitutional Court, it was made so much of an issue, so this is how I deal with it. As already stated in this judgment, the petition was brought under Article 137 of the Constitution. The allegations were that under Clause 3A, an Act of Parliament, and under 3B, a number of acts and omissions were inconsistent with or in contravention of the Constitution, and the petitioners prayed for annulment of the Act. The petitioners filed affidavits to prove the acts and omissions that would warrant annulment of the Act, and the Attorney General filed a number of affidavits in the defense of the enactment of the Act. The Attorney General did not find it necessary to include the Speaker or Deputy Speaker among the witnesses to swear affidavits. As a party defending the petition, a decision as to who would testify in the case was his prerogative, because he knew better the witnesses that would support the case he wished to present. The acts and omissions in the proceedings in Parliament were well documented by the evidence of the corrupt Parliament, the parliamentary hazard, and the evidence of some of the petitioners who were in the Parliament. So, the factual aspect of the case was well covered, and there was not so much controversy about what happened in Parliament during the enactment of the Impagement Act. What was in controversy was the constitutionality of the act's omissions and the Act itself. During the trial, the Constitutional Court, the petitioners sought the indulgence of court to summon the Speaker for cross-examination on a number of matters. The petitioners sought to rely on Rule 12, Sub-Rule 2 of the Constitutional Court Petition Reference Rules, which states that the court may, of its own motion, examine any witness or call and examine or recall any witness, its own motion, if the court is of the opinion that the evidence of the witness is likely to assist the court to arrive at a just decision. The appellants argue that apart from the Speaker and Deputy Speaker, who should have been called to testify on their lead role in the enactment of the Act, others who should have been called included the Minister of Finance, who would testify about contradictory certificate of financial implications, Honorable Raphael Majezi, who moved the Act, the President, who assented to the bill which was made accompanied by a valid certificate of compliance, and the Chairperson and Deputy Chairperson of the Legal and Parliamentary Affairs Committee of Parliament. On their own motion, the court did not find it necessary to call any witness outside those that had filed affidavits. Some of those that had filed affidavits, like John Metara, Head Civil Service, Casey Makanisi, Frank Mweswa, Asman Mugeni, David Mhozi, Honorable Namboza Wakereke, were cross-examined from the loads of evidence that was filed by both the petitioners and the respondent. With that cross-examination of the witnesses, the court was equipped with more than sufficient material to make the necessary interpretation as required under Article 137(3)(a) and B of the Constitution. As to the failure by the Constitutional Court to give detailed reasons as to why they found no reason to call the Speaker, the reasons advanced in this court cure the omission because, as a first appellate court, we are required to do a reevaluation and come to our own conclusion. I deal with the cross-examination after submissions. They had a valid, this one had it's a valid point. I agree with submissions of counsel that it was irregular of the court to take final submissions of the case before cross-examination. The submissions are supposed to be a final act in a trial before judgment. The evidence elucidated during cross-examination would be part of the comments during final submissions. In my own view, the cross-examination after final submissions was not fatal to the trial since the evidence was at the disposal of the justices and it would be taken into account during their own analysis of the case. I deal with the interjections. You will find it in the judgment. There was a complaint about interjections. Briefly deal with it. I deal with submission of authorities. I think this one let me read. Mr. Mavirizi complained that he presented his case with a number of authorities which court did not acknowledge. But all the justices support their findings with a number of good authorities from a number of jurisdictions. This might have been as a result of their own research, in addition to the authorities presented by the parties. They might not have mentioned who of the parties was the source of the authorities, but they were assisted by the authorities submitted by all parties, including Mr. Mavirizi. My sister has dealt with the delay of trial. I think, let me read something I've said about delayed judgment. I've studied Mr. Mavirizi's argument about the consequences of a delayed judgment. He cited a Nigerian case of Chief Ifezue, where a judgment was annulled for failure to deliver it within 90 days prescribed by the Constitution. In our case, it is the regulation in the Judicial Code of Conduct which courts should endeavor to adhere to. We had a valid point. I think there are delays. However, I would not go as far as saying that failure to deliver judgment within 60 days renders it null and void. The judgment of a court cannot be invalidated by reason of delay. In the instant case, the Constitutional Court made pronouncement on the constitutionality of the impugned act, and unless it is reversed, it remains on record as the judgment of the court. My sister has dealt with the issue of where the appellant was told to sit. And I think the CJ in his judge, the DCJ dealt with it very well, and you find the citation of what the DCJ said about that issue. And I agree with the guidance of the DCJ on this point. From wherever he was able to present his petition, and I do not see how his right to fair hearing was compromised by being denied a seat at the bar. I deal with the restrictions in cross-examination and a lot of other matters. But let me conclude this issue this way. In issue 7, in the conclusion of this issue, I wish to observe that some of the issues raised are valid, as I've tried to explain. However, none of the irregularities was fatal to the whole trial as would warrant an annulment as prayed by the appellants. This issue is answered in the negative. Issue number 1, whether the land justices of the Constitutional Court misdirected themselves on the application of the basic structure doctrine. I again summarize all the submissions by counsel. I also extensively cite the judgments of the justices at the Constitutional Court. Now, let's remind ourselves as to what was at stake at the Constitutional Court. This is how the issue was framed. Whether the act was against the spirit and structure of the 1995 Constitution. And to me, the basic structure doctrine as a judicial principle was well defined by all the parties in the consolidated constitutional petition and the Constitutional Court as well as in this court. Both the appellants and the Attorney General seem to agree on the doctrine, and in fact, the Attorney General agreed with Mr. Kwabo that the basic structure as defined by Justice Kapuru constitutes the basic structure of the 1995 Constitution, which should be adopted by this court. But before we proceed, we should observe that much as there are proponents of the doctrine, there are also its opponents. The opponents in the Indian judgment, which all of us discuss, out of 13, there were 6 dissenters, and one of the dissenters said this. I think it's important that we fundamental or basic principles can be changed. There can be radical change in the Constitution, like introducing a presidential system of government for a cabinet system or a unitary system for a federal system. But such amendment would in the wake bring all the consequential changes for the smooth working of the new system. The problems of the times and the solutions of those problems are considered at the time of framing the Constitution. But those who frame the Constitution also know that new and unforeseen problems may emerge, that problems once considered important may lose their importance because priorities have changed, that solutions to problems once considered right and inevitable are shown to be wrong or to require considerable modification, that judicial interpretation may rob certain provisions of their intended effect, that public opinion may shift from one philosophy of government to another. The framers of the Constitution did not put any limitation on the amending power because of the end of the Constitution is the safety, the greatness and well-being of the people. Changes in the Constitution serve these great ends and carry out the real purpose of the Constitution. Justice Sekoko cites this judge in the case of Paul Simogorere, which all of you cited. Then I cite the case of Tanzania, who also is an opponent, justice of the court in Tanzania, who is also an opponent. Now, I said that there were attempts by both the Indian court and the Constitutional Court to define what the basic structure of our respective constitutions are. But both the Indian court and the Constitutional Court did not come up with any one basic structure. All the justices in the Indian court and all the justices in the Constitutional Court each came out with their own structure. So I don't know what the best structure of this constitution is. So I set out all those attempts set out in this judgment. Let me read my conclusion. Throughout the trial at the Constitutional Court and the appeal before this court, there was no suggestion that the Indian Constitution is the same model as our Constitution, because our Constitution was structured according to our history. In our Constitution, there is a whole chapter 18 with the heading Amendment of the Constitution, under which there are various articles, including Article 259, Amendment of the Constitution, 260, amendments requiring referendum, 261 amendments requiring approval by district councils, and Article 262 amendments by Parliament, which I set up this Article 262. These articles give a framework within which the Constitution can be amended. I do not think that it is necessary to harmonize as to what the best structure of the Constitution is. As I've already stated, both the Indian Court and the Constitutional Court attempted to define what the best structure of the Indian and Ugandan Constitution is, but it was an exercise in futility. My understanding of the best structure doctrine is that within this framework, the Constitution is amendable, but it can still be protected from compromise of its own foundation and structure, so that every amendment is harmonized with the rest of the Constitution and the wishes of the people of Uganda. The framework provided under Article 259, 260, and 261 of the Constitution should not be seen as the license to the legislative arm of government to amend the Constitution the way they wish. As to whether this amendment was part of the best structure, it was adequately addressed by the Constitutional Court, which came to the conclusion that the removal of the age limit would not affect the basic structure of the Constitution, and I agree with that finding. The issue, therefore, is answered in the negative. Issue 2, which I think is the heart of this case. It was framed as follows: whether the land majority justices of the Constitutional Court add in law and fact in holding that the entire process of conceptualizing, consulting, debating, and enactment did not in any respect contravene nor was inconsistent with the 1995 Constitution. I go through all the submissions. Now, I cite Article 137, because again to me, this is where this case, Article 137, this is where this case lies. Especially, I cite the entire Article 137, but to me, 3A and B. 3A, a person who alleges that an act of parliament spelled with big A, or any other law or anything or in or done under the authority of any law, or B, an act spelled with small a, or omission by any person or authority is inconsistent with or in contravention of a provision of this Constitution, may petition the Constitutional Court for a declaration to that effect and for redress where necessary. Clause 4, whereupon determination of the petition under clause 3 of this article, the Constitutional Court considers that there is a need for redress. In addition to the declaration sought, the Constitutional Court may grant an order of redress, refer a matter to the High Court for investigate and determine the appropriate redress. It is in this same article that talks about expeditious resolution of matters before the Constitutional Court. I deal with charging the Consolidated Fund contrary to Article 93 of the Constitution. All the submissions in summary codified. In summary, All the submissions are here by all the parties. We can't go through them. Now, the termination of this Article 193 of the Constitution. I cite the article. Now, the essence of this article is to enable government to plan on how such a charge or other imposition on the consolidated fund can be effectively implemented. By it, without causing unnecessary restraints on its budget. This is to prevent Parliament from proceeding with bills and motions that create a charge on the consolidated fund. The Amendment Act had two certificates of financial implications. The first was issued upon request by Honorable Majeza and another issued upon request by Michael Tsime for an amendment to original Magezi bill to add a clause, the extension of tenure of Parliament. The issue of the second certificate having glitches was properly handled by the Constitutional Court, which found it have been irregularly issued. The other amendments of Honorable Nanda Mafadi had no certificate of financial implication. The majority of the Constitutional Court justices found that the Impoundment Act violated the provisions of Article 93 of the Constitution, and they contended that non-compliance only affected Section 26810 of the Act, which provided for extension. I concur with the Constitutional Court that the Magezi bill had no charge or imposition of the same in the consolidated fund. The amendments did. Under Article 93A of the Constitution, debate on the Magezi bill should not have proceeded. It was incumbent on the Speaker to resolve this issue before proceeding with the debate. The article forbids private members from introducing or proceeding with bills that make a charge on the consolidated fund. The language is in mandatory terms. I therefore find that the process of debating and passing the constitutional bill with its amendments that infringed on Article 93 of the Constitution was null and void and vitiated the entire enactment of the Constitutional Amendment Act. On the issue of 29 million, the Parliamentary Commission spent monies which were already appropriated. I would leave the matter for the Auditor General to establish whether or not there was misappropriation of the funds, much as its source was the consolidated fund. Consultation participation. I again lay down all the submissions. All the submissions on that issue are laid. The determination. As a brief background, I wish to quote paragraph 0.22 of the Odochi report, where the Constitutional Commission made the following remarks. The government also faced its challenges successfully. It created and maintained the atmosphere of peace, security, and freedom of expression so necessary for the success of the exercise. It left full freedom to the organization and the direction of our work. At no time did it in any way interfere with what we were doing. The people everywhere manifested signs of tremendous growth in political maturity. They discussed issues without quarreling or fighting. We observed no hostile tensions in any of the seminars or meetings we conducted as part of the exercise. Ugandans seem to have agreed that the constitutional making process was the critical exercise for the future peace and stability of Uganda. The process of consultation and passing of the Impoundment Act was the exact opposite of the above observation. The Magezi bill was from the outset very controversial, if what happened in Parliament on 26th and 27th September is anything to go by. Parliament was pluralized. The Honourable Speaker recognized the importance of the bill and adjourned the House to allow consideration by the Parliamentary Committee and consultation by members of Parliament. Unfortunately, the consultation by members of Parliament was interfered with and interrupted by a directive by the Inspector General of Police issued by Asman Mugenyi, which all the justices of the Constitutional Court condemned. I quote at length the judgment of Justice Cheborion, who in very, very strong terms condemned the act now small a. And I conclude, there is no doubt that this act was unconstitutional and the Attorney General considered so. In terms of Article 137, 3B, already cited in this judgment, what the Constitutional Court was required to do was to make a declaration, the consequences of which are that the process in Parliament following infringement of fundamental rights of not only the members of Parliament, but also members of the public, who might have been interested in participating in the consultations, vitiates the process. I talk about smuggling. I don't know who coined this word, but I think save time. I don't think a speaker can smuggle. That's what you find when you read this judgment. I don't think a speaker can smuggle an item on the order paper. That is her task. So, but the determination is here. I think I consider this one denying MPs adequate time to debate, and there are quite a number of acts which allegedly infringe the Constitution. So I'm picking out what I think should be, what I think is important, but all of it is here. In my view, the time given to each member of Parliament to speak is determined by the Speaker. Rules 69 and 70. But it can be seen from the answer that the majority of members who had an opportunity to address the House were timed out. If you look at the answer, almost every member. And Justice Kapuru gave the statistics, out of 452 members of Parliament, only 124 members of Parliament contributed or debated on the Constitution, leaving out others, notably the leader of opposition, pleading for time to debate. The time given for debate and close of the same is determined by the Speaker in accordance with Rules 69 and 70. I can only comment that the debate was rushed, leaving out members of Parliament who still wanted to express their views, yet in the first place it was the Speaker who had sent them out to go and gather the views of the electorate. There was also no time for debate on other aspects of the bill relating to electoral reforms as recommended by this court. But that again is, I think, the prerogative of the Speaker, and the court cannot interfere. Suspension of members of Parliament. I set down all the submissions. There were two suspensions by the Speaker. The first being on 27 September 2017, where the Speaker suspended 25 members for gross misconduct, which ranged from carrying a firearm into the chambers of Parliament and unruly conduct, which included failure to listen to the Speaker in silence, standing, climbing on chairs, tables. And the Speaker clearly explained to the members before suspending them under Rule 8 of Rule 2. There was a second suspension on 18 December 2017, whereby the Speaker suspended 6 members who included the Honourables Ibrahim Semudu, Alan Siwanyana, Karahanga, Jonathan Udu, Mubarak Mnangagwa and Anthony Akol, without assigning any reason for their suspension. I'm aware that the rules of procedure of Parliament clearly show that the procedure to challenge the Speaker's ruling, which is by motion. The members should have taken that course of action, and this court cannot intervene where this specific remedy is available and the members are permitted to take it. Failure to close doors, I deal with it. I don't think, you'll find it. Now, let's deal with the certificate of compliance. Certificate of compliance and presidential assent are mandatory requirements that must be met before any bill can become law. Article 91 and 263 of the Constitution. Parliament passed the Constitution Amendment Bill, which in fact amended Articles 61, 102, 104, 183, 77, 105, 181, 289, 289A, and 291 of the Constitution. The Speaker prepared a certificate of compliance in which he included Articles 61, 102, 104, and 183 of the Constitution as the only ones amended and excluded the others. The Speaker was supposed to send the entire bill with all the articles amended and passed by Parliament to the President. The majority of the Constitutional Court just found her action to be irregular if you read through the judgment of Justice Chebori. The land justices properly explained the importance of a certificate of compliance and clearly stated it's a mandatory requirement under Article 263 of the Constitution. This position was well stated in the case of Semogere, and with due respect to the majority of the Constitutional Court justices, once it was found that the certificate of compliance was fatal, it is a contradiction to conclude that it was valid. I therefore find there was no valid certificate of compliance prepared by the Speaker. I don't know whether I should intervene and say that I'm not interested in this either cracking or what. This is a court. I think we should... on the illegal assent to the bill by the President. Having held that there was no valid certificate of compliance, it follows that there was nothing valid to assent to. I found that there was no valid assent to the bill by the President. I deal with the failure to comply with the 14 days. Now that one clearly refers is concerned with the with the Nandara and Tusime motions, amendments. Let me. But it is here. Debating in absence of the opposition leader, I think the Constitutional Court handled that one very, very well. I'm not, because I don't think the Speaker had any choice if somebody decides to walk out. And that is what the judgment is. Crossing the floor of Parliament. I don't even know why we took a lot of time. How does somebody cross because he has sat on the other side? Crossing is mental, not physical. You find that is how I deal with it. I mean, if you follow the judgment of the Constitutional Court, it's exactly what I what I think. Signing the report, I don't think the signatures, those extra signatures, made it unconstitutional. It was shabby, but I don't think you can say it was unconstitutional. I'm trying to summarize so that we. Now, let me go to severance, because I have found that a number of acts were unconstitutional. Would you sever them from the original Magezi bill? This is my take on severance. The majority of the Constitutional Court justices applying the principle of severance severed the amendments which were introduced by the Honorable Tsime Michael on the extension of tenure of Parliament and that on Nandra Mafari on the limits at the committee stage of the whole House from original Magezi bill. I don't agree with Mr. Mavirizi that because the principle was not pleaded or argued by any of the parties at the trial, the Constitutional Court was precluded from applying it. To me, if court through its own research finds a principle that may have been missed by the parties but is helpful in solving the case, there is nothing to stop the court from relying on it. The concern to the parties should be whether the principle was actually applicable or the court was misconceived in applying it. The above two amendments emanated from the Legal and Parliamentary Affairs Committee. The general recommendations were where the committee recommended for reinstatement of presidential term limits. During the debate of the report of the committee, some of the members of Parliament supported the above amendment, the one on restoration of term limits, and actually influenced debate. I sample a few. I can take the one of Honorable James Warswaka, NRM Bunyere County West of Tareja. He says, my people told me that we restore the term limits, not only for the president, but for all elected members of parliament. There are members of parliament who have been for several years, but they do not want to leave. Why don't they serve 2 terms and go? Then the same Kenneth Rubogo, Violet Uproot. Let me sample the one of Alex Biargawa, NRM Isingiro County. He states, it was on that basis that I took my consultative meetings to the 5 sub-counties in my constituency with a population of about 220 people. I traversed all the sub-counties and corrected the following. Yes, sometime in Parliament, term limits were removed. My people instructed me to come back and share with you that we must keep this country together and that term limits must be reinstated and entrenched. And if you read the judgment, there are many others, and there are those who spoke against the term limits. Later, when it comes to the second reading of the bill, the Honorable Beatrice Sanywa stated that, Madam Speaker, on lifting the term limits, I vote yes. she was called back by the Speaker to vote properly. And she voted yes, but her support for the bill was clearly influenced by the return of term limits. I'm of the opinion that the amendments introduced were not foreign to the Magezi bill. The members of Parliament were sent out by the Speaker, and she emphasized that they should properly consult the people in accordance with Article 1 of the Constitution. The members during the debate clearly demonstrated that their voters had strictly demanded for a statement of the term limits. At the committee stage of the whole House, the Honorable Sim sought permission to introduce. I talk about the introduction of the term limits report. The Deputy Attorney General moved to block the amendment by the Honorable Mafal because it was not debated and it was a matter for a referendum. After the committee stage, the chairperson put the question to members. The title "Do the bill and hazard" shows that the question was put and agreed. From the above, it is crystal clear that the two amendments were proposed and voted upon by the members of Parliament in the committee and agreed that they form part of the original Magezi bill. From this moment up to the conclusion of the process, the amendments became an integral part of the bill, judging from the report of Raphael Magezi indicated below. This is what Magezi states. Madam Speaker, I beg to report that the Committee of the Whole House has considered the bill entitled the Constitution Amendment and passed the entire bill with amendments, and also introduced and passed new clauses amending Articles 77, 181, 29, 291, 105, and 260. I beg to report. At the motion for adopting the report from the Committee of the Whole House, and again, Mr. Magezi states, Honorable Magezi states, Madam Speaker, I beg to move that the report of the Committee of the Whole House be adopted. The Speaker put the question to members that the report of the Committee of the Whole House be adopted, and the answer shows that the question was put and agreed to. The bill went on to the third reading. The Honorable Magezi moved the bill to be read for the third time and do pass, and the Speaker put the question to members and voting for the third started. I have reproduced the above part of the answer to show that the amendments by Honorable Simon Mafari were passed by members of Parliament and allowed to be added on the original Magezi bill at the committee stage. Secondly, the report of the Committee of the Whole House, which contained the amendments, was adopted by members of Parliament. Thirdly, the third voting on the bill was done as one. Fourthly, the act was passed as one by Parliament, and lastly, some members of Parliament, as seen from the above, were sent by their people to reinstate the term limits. The Constitutional Court, just with due respect, misconstrued the doctrine of severance, because from the time of the introduction, the amendment, the bill became one. The Speaker left out the contents of the amendment in her certificate of compliance, which rendered the certificate invalid, as already determined by in this judgment. The second point about the misapplication of the principle is that well before the introduction of the amendment to the bill, the process of enacting the act was already tainted with acts of unconstitutionality already discussed in this judgment. In conclusion, having found that some of the acts and omissions vitiated the enactment of the Constitution, the doctrine of severance was wrongly applied by the Constitutional Court. The act was passed as one, and I find the principle inapplicable. I answer issue number 2 in the positive. Violence. Issue 3. I set out all the submissions again. I'll go to the this is how I come issue 3. The Constitutional Court unanimously found, and rightly so in my view, that given the gross indiscipline of some members of parliament who were involved not only in shouting, marching, complete disregard of the decorum of parliament, but also in a brawl or in full view of the speaker was left with no alternative but to wield the stick and suspend the offending members of parliament, members of the house. As a court, we should not be seen to interfere with the discretion of the speaker to rein on errant members of parliament to protect the integrity of this house as the circumstances prevailing warranted. However, what I find disturbing and of concern to this court is that after the speaker had pronounced her punishment, the execution of her orders was bungled by what she describes as strangers in her letter to His Excellency the President, which I reproduce here. I think you all know what she says. I do not need to go any further than this communication from the Honorable Speaker as to the unconstitutionality of the actions by the strangers. That is her word. There is no evidence that anybody responded to her concerns, which raises a question of interference of one branch of government into the activities of another branch, which is a breach of the Constitution. The second question it raises that members of parliament, including those who were not on the speaker's list, were assaulted, thrown on public vehicles, detained, and released without charge, all of which amount to inhuman treatment, which is in contravention of the Constitution. In terms of Article 137, Clause 3b of the Constitution, I would interpret both the acts of interference with the work of Parliament as complained about by the Speaker and his treatment of members of Parliament as unconstitutional. The provision of the Constitution does not require this court to inquire into the consequences of an unconstitutional act, as the Constitutional Court did, and neither is it required to make an order for redress. The unconstitutionality of the act vitiates the process, and I find issue number 3 in the positive. Substantive test, I think, yes, let me go straight to what I think the Constitutional Court misconstrued. That is issue number 4. The substantiality test as applied in electoral petitions simply means that even if court was find that an election was not conducted in accordance with the principles laid down in those provisions, it is required to find that non-compliance affected the results of the election in a substantial matter. I set out the provisions of the Parliamentary Elections Act and Presidential Elections Act, where the provision is made for application of the substantiality test. It was a misdirection for the Constitutional Court to apply the substantiality test as it is applied in electoral matters. Secondly, the Parliamentary Elections Act and the Presidential Elections Act make a clear distinction between the illegal practice where the substantiality test is applicable and an electoral offense where the test is not applicable. I would put an unconstitutional act in the category of cases where it is impossible to apply the substantiality test, as I illustrate below from the Attorney General's argument. The Attorney General argued that the substantiality test is used as a tool evaluation of evidence, and I agree. If the evaluation of evidence is for determination of an election result, the test is specifically provided for by the statute cited in this judgment. If the test was for general application in evaluation of evidence, it will not be necessary to specifically provide for it in the election-related matters. On the other hand, if the evaluation of evidence is related to interpretation of the Constitution under Article 137, Clause 3 of the Constitution, the substantiality test is irrelevant Because once a petitioner makes a case that an act or act is inconsistent with or in contravention of a provision of the Constitution, the proof of inconsistency or contravention does not require application of the substantiality test. In my view, a constitutional infringement in relation to any act or act that is declared unconstitutional under Article 137(3)(b) of the Constitution cannot be subjected to the substantiality test. An infringement on the supreme law, which is the Constitution, is a grave matter. Its interpretation does not go beyond the declaration unless there is a need for redress under Article 137 of the Constitution. This issue is answered in the positive. Issue 5, I think my sister dealt with issue 5, but let me, all the submissions are here. In my finding in issue 1, I opined that the Constitution is amendable as long as the procedure laid down in Chapter 18 of the Constitution is followed. I cite Article 79 of the Constitution. The petitioner's appellants put forward arguments against the removal of the age limits while the Attorney General vehemently defends their removal. I would not go into the merits or demerits of removal of the age limits, because if the people of Uganda, through their representatives, decide to remove them, the debate goes to the legislature and not to the Constitutional Court. Evidence was adduced of what transpired during the debate in Parliament, and it is very clear that's where the debate belongs. The issue is answered in the negative. On whether the Constitutional Court had in law, in fact, holding that the President elected in 2016 is not liable to vacate office on attaining the age of 75 years. I also don't know why we ended up with this type of issue, but I resolved it this way. The issue was framed as at the Constitutional Court as issue 13 and stated as whether the continuance in office of the President of Uganda by one who was elected in 2016 and who attained the age of 75 is consistent with only contravention of Articles 83, 1B and 102 of the Constitution. All the Constitutional Court justices found that the office of the President does not become vacant on the incumbent attaining the age of 75. One of the principles of constitutional interpretation already stated in this judgment and explained by the Attorney General in his submission is that where the words of the Constitution are clear and unambiguous, they ought to be there, given their primary, ordinary, and natural meaning. I'm in full agreement with the Constitutional Court, and my interpretation of Article 102B of the Constitution is that the qualifications referred to are pre-nomination qualifications and not mid-term. I do not think that the framers of the Constitution intended, for example, that a 74-year-old person would be qualified for election, but a year later, he or she no longer qualifies, and the country goes through another election. I cite Article 102. So quite clearly, the office of the President does not become vacant on attainment of 75 years of age of the incumbent. The issue is answered in the negative. Issue 8, I'm ending. Issue 8 required this court to determine the remedies. And it follows from my finding that as a consequence of a number of acts that infringed on the Constitution in the process of enactment of the Constitution, the act cannot be allowed to stand and is hereby annulled. It also follows from my finding that and declaration that there were acts which were inconsistent with and in contravention of the Constitution, and the prayer for nullification is granted. On courts, I would order that each party meets its own process. Let me put my signature in Teams.
I think on this note, we'll take a break, and it's lunchtime. I think we'll resume at 2 o'clock for the rest of the judgments.
How was Gulu for you?
Gulu has been blazing hot, no doubt about that. And the dance auditions have been steaming hot.
This week, we are moving on to the Western region. Dancers in Mbarara, dancers in Kabale, dancers in Tungamo, in Masaka. Let's link up in Mbarara at Ajip Montel this Saturday, 20th of April at exactly 8 a.m. and bring it on. Up for grabs is 38, you get $1 million shillings. This is the NTV Sting Hot Steps Season 5.
Hot Steps is proudly brought to you by NTV and Sting Energy Drink. Sting, live switched on.
See, being a CEO comes with the territory, the status, the privileges, and the challenges. Like this course, one needs to know how to navigate the terrain in order to deliver.
I hear you. But my biggest challenge now is how to raise money to remit my employees NSSF. And I'm 8 months behind.
If you must remember anything from this conversation, always remember that non-remittance of employees' NSSF contributions is a crime, and CEOs and their directors can be sued and locked up. But not all is lost. Within the 90-day NSSF amnesty window, all defaulting employers have an opportunity to negotiate a payment plan and get up to 95% of their penalties waived.
These are the times I enjoy being a CEO. Problem solved. Just like that.
Call our toll-free line to apply and find out more about the 90-day NSSF amnesty window. NSSF, a better life.
In celebration of the International Jazz Day, Johnny Walker and Isaiah Katuma present global pop star and 3-time Grammy winner Angelique Kidjo. Don't miss a special electrifying performance by Africa's premier diva with a special guest, the Grammy-nominated Billboard-topping saxophonist Darren Rand, together with our own Isaiah Katuma, all on one stage at the Kampala Serena Hotel on 30th April, starting at 7 p.m. Tickets are 200,000 shillings and 4 million shillings a table. Get your tickets at Serena Hotel and Conference Center. For reservations, call 0776 100 009. Proudly sponsored by Kampala Serena Hotel, NTV, Pinnacle Security, Victoria Motors, Fenon Event, and Johnny Walker. Keep walking. Not for sale to persons under 18. Drink responsibly.
Rockball is a spirit, a way of life, a relentless form of energy, with a spirit of endurance and high performance, and fast energy recovery after a tiring job. Rockball, Uganda's favorite energy drink. Rockball, feel the positive energy.
politics bamujje mu security eggwanga lyaffe ligenda kukola ki kufuna obuzibu nze omuntu wa wansi atuula wansi ku ttaka ssebo nze ngenda okuweerera omwana oyo ng'onzimbidde essomero lya kalina
naye ne gavumenti oba eri munkwe etubuzaabuza tekutula eri awo tulage eno tulage eno esayidi katale n'esayidi katale akati abantu ate koona abantu basale nga badde eno nga badde eno emmotoka zibakoone awantu atwaka gavumenti etekawo sente wetulaba ambulensi zetuzibira omuntu n'awulira akagombe ka ambulensi ng'ereeta mulwadde n'alemera mu kkubo.
This is Biabekul #1 member.
You have what? Omutte yaliwo ku bobote nze kolere kyo wa Museveni.
Akajiga bwakwongeza bwati.
Abavudde eggoma mwangwe basi ebaleka.
Waliwo omuwumbo nawe n'okwekanga komaawo bubonero busatu.
Don't touch that dial, keep it locked.
siri muyembe
Amunange mbero.
This is your one and only queen aka Swag Mama.
This is Jaguar and you're watching Comedy Store with
Alex Muhanje.
Oh, what a feeling, my whole world is changing. Woke up, I was feeling down, but now I'm not complaining. Thanks to my 3 lucky numbers, you too can win if you enter Super 3 and feel super like me. I'm feeling super, Zendy super. I'm feeling super, Zendy super, yeah, yeah, yeah. Super, Zendy super. I'm feeling super, Zendy super, yeah, yeah.
Okukubiriza programu eno tuwaye n'okugitegeka libeera bbanja lyennyini tosobola kuwumula okutuusa ng'olisasudde. Entebe eno eteekwa okugasa abantu buli wiiki.
Omurasita kyanoonya gwe kyolina
lwa butayagala kumanya.
exactly n'obeera era bannange gavumenti etuyambe.
Nyongera kubabuulira nabagamba emyaka ng'ebiri egiyise nti lwakiri waliwo be neetaaga okusabira mukama abanonne.
Ebeera interview omuntu gy'ateekeddwa okulaba. Yattaluumu wamulabako n'amaaso.
Moses.
Wali omumanyi?
Nali mumanyi bali bayita Moses Safi.
Nti lwaki nkola activism Museveni agenda okujja naye nze nga njagala Museveni.
Okunoonyereza n'okutegeera obulungi akyadde ku programu kikulu kijjayo emiramu emikulu tuwaye kwesimbi. Buli kimu tukyetegekera. Tutambula okunoonya abali mu buufu obw'emiramu egyatuwaye abalabi baffe baliko emboozi gye baagala okuwulira.
Okuva e Kaddugala paka Kampala gajira ku motoka y'amatooke emabega.
Eyigiriza esoomooza
naddukamu katono we ne gukuba omukono.
Paul kinno ssebe ekugwi
zino HV zino nnene
ewuniikiriza
yalowooza nti bagenda musala ku kugulu yadduka
eteeka ku bunkenke.
Aba ali mu ssabo yeefuula alagula aliko emmandu empitirivu ennyo nga mugajjajja byontumye embireezi nti ebiriwo ajja ekikapu akimugundirawo mu maaso ogenda okukebera nga mutwe gwa mwana omukazi n'agwa
mwagala oli otya
naye n'akuddamu
nzimanyi nnyo ebbaluwa
kasonsomolera ng'erigoledde feddo
otyo. Tuwaye ekyusizza ate ekyayongera okukyusa ebiseera bya Uganda kubanga ddoboozi lyogerwa ate liwulirwa.
Rachel, how was Gulu for you?
Gulu has been blazing hot, no doubt about that. And the dance auditions have been steaming hot.
This week, we are moving on to the Western region. Dancers in Mbarara, dancers in Kabale, dancers in Tungamo, in Masaka. Let's link up in Mbarara at Ajip Montel this Saturday, 20th.